In a second. Good morning. Thank you for those of us who are joining us live and virtually. If you have any technical questions, please contact somebody in the staff here in the room or send a message in the chat. We are going to be recording. We'll get started in just a minute.
Good morning, everyone. It is now 9:07, Thursday, April 9th, and I am calling to order the meeting of the Los Angeles Probation Oversight Commission. I am Dolores Canales, Chair of the Commission. We look forward to hearing from our panelists, commissioners, and the public today about many important issues, and thank you all for joining us. The three main issues today, and we have set timeframes to discuss and act on each topic. So hopefully we can get through everything today with a robust discussion. This may mean I have to ask panelists and commissioners to limit your discussion in order to get to public comment and be ready to vote or to move on. Today's meeting is scheduled as follows. We will quickly get through our administrative items and begin with a presentation by the Chief, OIG, and Laura Ridolfi from the Burns Institute about progress on probation's depopulation plan and how probation's recommendations on intake and detention impact the overall population. The OIG's report, which is attached to the agenda, includes recommendations that the Commission may choose to take action on. At 10:30 a.m., we will move into our agenda item on probation's visitation policy and procedures. Representatives from Probation and OYCR, as well as Commissioner Shipp and Dr. Sarah Gongora will share. Finally, after a short break at approximately 11:35, we will have a presentation and discussion on probation's budget and consultant contracts. If we have time, we will hear a short report from our executive director. She informs me that she requested the information from the last meeting and previous meetings has been received, so we may skip that item if time does not allow. We will end with general public comment. Thank you for joining us today, and let's go ahead and get started. And now I will turn over the meeting to the Executive Director, Wendy Julian, to explain how you can participate during today's meeting, and then she will take the roll call.
Thank you, Chair Canales, and good morning, everyone. Welcome to all of those who are here in person and those attending online. Thank you to all of our commissioners for being here today. We encourage all of your participation in the meeting. We welcome your comments in writing or live in person today. There will be an opportunity for public comment on each agenda item, and then again at the end of the meeting for items that are not on the agenda. For the items that are on the agenda, Chair Canales will introduce them in the order that she just explained, and then we will hear your public comments before the Commission takes any action on the item. If there are more folks who want to participate than we have time for, we will consider scheduling additional town halls for specific issues. As a reminder, please remember to speak directly into the microphones. That goes for all the commissioners and panelists as well as public commenters. That allows our virtual audience to hear you clearly. I'd like to share the following code of conduct, asking us all to respect the following guidelines. Please stop speaking immediately when your time ends. Please make sure your public comment relates to the subject matter of the item. Remain respectful of each other and the forum. If you are here to participate, it's really easy. You just come up to the podium, nothing formal. And if you have joined via WebEx or telephone on WebEx, you use the little raise your hand function to join the queue. On WebEx, there's a little hand icon at the bottom of the screen. And if you're calling in, you have to press *3 on your phone to activate the raise hand feature. Once we call on you with your phone number, you have to unmute yourself. We'll unmute you and you unmute yourself. If you're on your phone, to unmute yourself, dial *6. If you have any questions or concerns about being able to participate, please send a message in the chat to the host. All commenters today will have 2 minutes unless Chair Canales determines otherwise based on the number of people signed up for each item. If you'd like to make your comment in writing, we'd love to see it. Send us an email, info@poc.lacounty.gov. Somebody will put that in the chat for you. Please don't send your public comment in the chat. Only our staff will see it. It won't be logged as public comment, and it won't go to the commissioners. It also doesn't comply with our Brown Act responsibilities. If you need any accommodations, any help of any kind today regarding materials or making public comment or your participation, please contact Janae or Sarah in the back of the room. We are broadcasting our meeting live today via our YouTube channel and recording the WebEx presentation, but there's no engagement with users on YouTube. We encourage you to subscribe to our YouTube channel. There's all kinds of great things you can watch on there, live meetings, recaps, recordings, and we publish a lot of the other things that go on that relate to our work. You can also follow our social media accounts on Facebook, Instagram, Threads, and Blue Sky. I don't even know what that is, but I think we have it at LA County POC for more information about our meetings, and please invite others to attend. Buenos días, están muy bienvenidos aquí a la reunión. Ya hemos empezado vía WebEx y también en persona. Si le gustaría hacer un comentario público, por favor, tiene que hacer clic en la imagen de la mano y abriremos su micrófono. Está en la parte baja de la pantalla. Si está escuchando la conferencia por teléfono y quiere hacer una pregunta, tiene que presionar estrella 3 en su teléfono. Le avisaremos cuando sea su turno. Si está viendo la conferencia en vivo por YouTube, no puede participar dando comentario público, pero nos puede enviar un correo electrónico. Si quiere hacer sus comentarios en español virtualmente o aquí en persona, le daremos el doble del tiempo y podemos proveer traducción al inglés, o usted puede proveer su propio traductor. Al iniciar su comentario, nomás avísenos que quiere hacer su comentario en español. También estamos empezando a trabajar con una nueva tecnología que ayuda con la traducción de las reuniones. Si le interesa eso, puede hablar con nuestro equipo que está en la parte de atrás del cuarto y le podemos ayudar con eso. I'm going to call the roll now. Commissioners, please respond when I call your name. Commissioner Brooke Harris. Commissioner Ishay Jackson is absent. Commissioner Millie Kakani. Commissioner Don Meredith.
Here.
Thank you for following directions. Commissioner Eduardo Mundo. Commissioner Sam Prater is absent. Commissioner Tyreek Ship.
Here.
Commissioner Diane Terry. And Chair Dolores Canales. Chair Canales, with Commissioners Jackson and Prater being absent, we have quorum, and I will turn it over to you.
Thank you, Wendy. Let's start with agenda item number 2, approval of the March 12th, 2026 minutes, regular meeting minutes. And Wendy, do we have any public comment? All right, can I have a motion to approve the March 12th, 2026 regular meeting minutes? Thank you, Commissioner Kakani. Thank you, Commissioner Harris. All right, so we have a motion by Commissioner Kakani, seconded by Commissioner Harris. Are there any changes to the minutes? Hearing none, commissioners, please vote with a voice vote. All in favor? All right, thank you. Any opposed? Any abstentions? Hearing none, motion carries. Okay, so now we're moving on to agenda item 3. For agenda item 3, we will discuss and take action on progress the Los Angeles County Probation Department has made on implementing its depopulation plan and probation's role in reducing the overall number of youth detained. Attached to the agenda are several items, including the POC reports, probation's depopulation strategy, an analysis of probation's intake and detention strategy, with probation's response, and finally, the Office of the Inspector General's assessment of probation detention reports. Here to present on this item are, Chief Guillermo Villarosa is on his way. Interim Inspector General Eric Bates and Deputy Inspector General Frederick Lacey from the Los Angeles County Office of Inspector General OIG, and Laura Rodolfi, who is the Racial Justice and Wellbeing Strategist at the W. Haywood Burns Institute. Laura is going to start us off with an introduction to the topic. Then we will move on to probation and finally hear from the OIG. The OIG report that they will discuss contains some thoughtful recommendations that the POC can consider supporting as part of this item. Welcome, Laura, and thank you for joining.
Thank you so much. Can everyone hear me?
Yes, we can.
Great. And you can see the presentation in the background. I can't see what is there.
We can't, but it's going to come up momentarily.
Okay. Well, I'll just go ahead and get started with a little introductory comment. Thanks so much for that introduction. My name is Laura Rodolfi. I'm really honored to be here this morning to talk about pre-adjudication detention and depopulation. For those of you who are unfamiliar with the Burns Institute, we work towards what we call structural well-being, reimagined system of public policies, institutional practices, and cultural norms that work together to strengthen families, communities, and individual outcomes. It's really a direct challenge to an operational framework of structural racism that really drives what currently happens to young people in systems like this. And here in LA County, the Burns Institute has been a partner in Youth Justice Reimagined for many years and in the ongoing work of transformation. So our goal organizationally is not just to shrink a system, it's to transform it. Decarceration, genuinely moving young people out of incarceration and into communities is a critical step in that path, but it's just a step, it's not the destination. Youth Justice Reimagined asks a deeper question, not just how do we get fewer young people incarcerated, but how do we build something worthy of them instead. So today I'm going to talk a little bit about depopulation because it matters urgently and because it's within reach, but I want to hold both truths, the work of reducing harm right now and the work of building a system that we actually want. You can go
Laura,
to the
presentation is up on the screen. So if you just want to note while you're talking to have us go forward to each slide.
Great. Go ahead and go to the next one. Before we get into local data and strategies for depopulation, I want to ground us in why this matters. Detention, even short-term pre-adjudication detention, disrupts adolescent development. It increases the risk of depression, self-harm, suicide. It makes it harder to return to school, reduces the odds of graduating, and it's a strong predictor of deeper system involvement. We're not holding youth in juvenile hall and releasing them unaffected. Every single day a young person spends in pre-adjudication causes them harm, and the harm that's happening is not being distributed equally. Black, Latino, and Indigenous youth really bear the brunt of the system in ways that white youth simply do not. They're detained at higher rates, they're held longer, and pushed deeper into a system that was never designed for their well-being. You can go to the next slide. Getting to detention requires passing through multiple gates, and at every one of those gates, the law provides an off-ramp. Every one of the boxes that you see up on the screen shows what those off-ramps are, and it tells you who's eligible for release at each stage. And what I'm going to show you is that LA County right now, in the county, those off-ramps are not being used to the extent that they could be. In many instances, they're really being bypassed as a matter of practice and local policy. You can go to the next. So the first gate belongs to probation. Just want to ground us in what the law says. When a young person arrives at intake, the law is really unambiguous. Probation must immediately release a young person to their parent or guardian unless two things are found true. First, that continuance in the home is contrary to the welfare of the young person. And second, that at least one of three grounds exist: urgent necessity for protection, a likelihood to flee, or a violation of a court order. That's it. Those are the only grounds for detention. Otherwise, it is presumed that the young person should be released. You can go to the next. At the detention hearing, the judge applies a similar standard. All three elements that you see up here must be present. And even then, the court first has to consider whether available services would prevent detention. And here's how this connects to probation. The judge is working from the detention report that probation writes. If that report doesn't recommend release, if it doesn't even raise release as an option, the judge is starting from a document that presumes detention. And so it's critical at that stage that the judge has all the information that they can and all the resources available at their disposal to ensure that the young person can be released as it's aligned with the law. You can go to the next one. So I'm going to get into a little bit of data, and everything I'm going to show and talk about comes from 3 sources. All have been produced in the last 6 months. The Probation Oversight Commission's intake detention analysis from February, probation's response to that analysis from March, the Office of Inspector General's assessment of the 135 detention reports from March, which also draws on the LADS risk assessment data in a report that was put together by the Oversight Commission. All of this, it's not outside advocacy. These are all from internally from Los Angeles County. This is the oversight and accountability that's doing exactly what it's supposed to do. And what all of these found is that there are really good opportunities to advance the depopulation plan. You can go to the next one. So as you likely know, the probation oversight's analysis found that detention is functioning as a default. Serious offenses, 707B cases dropped from 61% to 36% of intakes between 2024 and 2025, but the detention rate hardly moved during that time. Serious offenses nearly halved, but the detention continued. And overall, 72% of young people were still recommended for detention at intake. And for CDP, the conditional detention alternative represented only 21% of intake outcomes on average. And when it was used, it wasn't used immediately. In 2025, 98% of the CDP cases were still detained at first at intake. So CDP is functioning as a delayed release mechanism, but not as an immediate alternative. You can go to the next one. And probation's response to the Probation Oversight Commission raised some real constraints on their ability to depopulate. And I want to acknowledge them because they're legitimate. The DA charging decisions and court stacking, transfer motions that tripled in a year, a very long length of stay for transfer hearings. But the court order, population target of 175 at Los Padrinos, currently sits far above that. And the DA and the courts are absolutely contributing to the problem. But this is the through line today. There are still decision points that remain within probation's control that are not being utilized to the extent that they could be. And that's what we'll get to. You can go to the next one. As you also mentioned, and I think it sounds like we'll hear more about later, the OIG report that was released was an assessment of 135 reports, and every report, from January of 2025, none of those reports recommended unconditional release. None, zero. And the OIG also found a general bias in favor of detention. That is the language that they used in the report. They found that decisions reflect subjective judgment of the reporter and not objective criteria, that there were factual errors. One young person was falsely marked as a 707B offense, but it was his first time offense. Another had violated a court order, but it was his first arrest. They found that the LADS score, the risk tool that probation uses, never reached the judge. So the judge has no idea whether probation's own risk assessment analysis supports the recommendation that's in front of them that day. You can go to the next. And going back to a report from earlier that you likely remember, here's what that tool actually showed from an analysis in December of 2024. Of the 521 youth in custody on that day, 100 or about 20% scored low risk. So the OIG would suggest they release, and the tool would suggest they release. Almost half of the young people scored a medium score. So the OIG and the tool would suggest that they be considered for CDP. That's well over half, 63% of the detained population that was scoring low or medium using the probation's own tool. And even among youth accused of 707B offenses, 66% scored low or medium. So, just noting here that although, as we talked about earlier, mandatory referral to custody, for those cases initially doesn't mean that probation cannot recommend release at the detention hearing. When the judge is seeing the young person, they fully have discretion to make a recommendation for release. And that is an important distinction, and that really matters as we move forward. You can go to the next one. I want to pause for a moment too, just to talk about the risk tool generally, because the Burns Institute, has a position on this. Risk tools are an important way to create objective mechanisms for reducing population, but they are not neutral. A tool that's built on prior arrest data inherits all of the bias of a system where Black and Latino youth are arrested at higher rates for the same conduct. So even a well-designed risk assessment tool can reproduce inequity under the cover of objectivity. And that doesn't mean the LADS data isn't useful here. It is, it's important, but accepting that high risk as a justification for incarceration means that we're accepting that incarceration is the best response to those young people. And we really believe that there's a different answer to that. And I'll also add, on a personal note, in 2009, I wrote a memo to the LA County Probation Department raising concerns about the LADS before it was implemented. Part of what drove that memo was a very high override rate on the former tool, the Chrisberg scale, that the LADS was meant to replace. It had an 84% low risk youth who were detained based on it, and 92% of those overrides were youth of color. So we warned that a tool built on prior arrest would inherit that disparity, and that's exactly what was found in that OIG report, and that found that subjective judgment overriding objective scores, zero conditional release recommendations. So that same pattern that we were noting is happening here using a different tool. So just noting this is an important piece of information, but we need to be digging deeper and finding out more about what's driving detention as well. You can go to the next one. I want to, there's been many strategies I know that you've talked about in this space, and that came out in the report, and that I'll talk a little bit more in a moment. But I wanted to highlight one additional strategy that I don't know you've talked about in this space before that's happening in San Francisco. They have something called DDAP, the Detention Diversion Advocacy Program, that was designed specifically for young people who are charged with serious offenses, who would otherwise be detained. Case managers build individualized release plans and present them to the court immediately. And they did an independent evaluation of that program and found that young people who were remained in custody were 1.5 times more likely to have a new case than kids who were on the DDAP program, and were 2.3 times more likely to receive a subsequent felony referral. So this is, just an important strategy to think about all the different ways in which, depopulation strategies can borrow from other counties that are doing work with that same goal in mind. You can go to the next one. So I want to go back to sort of, what is and is not in control of probation, and what the commission could ask of the department. And we talked about that there's a lot of different drivers of detention that probation can't control. But there is also a lot that they can control. First, release and CDP recommendations practices. Having zero unconditional release recommendations in 135 reports is not a DA outcome or a court outcome. That is a probation outcome. So one recommendation or idea could be to require justification in written form that considers release consistent with what Welfare and Institutions Code Section 628 actually requires. And separately, CDP, it represents only 21% of intake outcomes. And like I said, in 2025, 98% of those were detained at first. So thinking about how do we monitor that data and report it monthly or on a regular basis to this commission to find out what's happening and not just a one-time snapshot to look at. Second, whether the LADS score ever reaches the court. Officers obviously use this assessment at intake, but it's not reaching the bench. So the judge has no idea whether probation's own tool supports the recommendation that's in front of them. And this is a policy choice, not a legal mandate. So, think about a policy that would require the full LADS, so that the judge has information about what's driving those scores, again, to ensure that bias isn't driving a higher score. And then the final score in every detention report given to the judge, the DA, and counsel. Third, looking at the categorical detention policies and overrides. Probation has created internal categories and treating them as mandatory detention triggers. They're not. None of the categories are required under Welfare and Institutions Code Section 628. The law actually requires individual assessments. So, and there's 3 grounds: urgent necessity for protection, likelihood to flee, violation of court order. That is it. So when probation says a category of offense requires detention, they're describing a policy that they created, not what's the law. So I'd recommend a review of those categories and ongoing monitoring to ensure that every decision is justified against the actual statutory standard. Fourth, the quality and accuracy of those reports. As was noted, there's errors, inconsistencies, misapplied standards. Judges rely on those documents. So, considering, as the report shared, training, ongoing auditing of those detention reports, and requiring a written justification for any report that doesn't consider release consistent with WIC 628 and what it actually requires. And then fifth, case reviews. The Board of Supervisors directed probation to conduct ongoing reviews of youth detained pre-adjudication. And as you heard from Lisa Macaluso, I think probably a couple of years ago at this point, this kind of ongoing review is really a cornerstone of effective detention reduction and expediting that process. So, continuing that process and making sure that those that review and the data from that review come back to this commission for reconsideration of how that's going and where tweaks need to happen. And that is it. I have all the information I have for you today. I think I'm at my time too.
Okay, thank you. Thank you so much for that presentation. Commissioners, before we move on to our next presenter, does anyone have any questions or comments? Yes, Commissioner Harris.
Thanks. Hi, Laura. Could you just unpack a little bit more the categorical policy detention and overrides idea? I think that's something that I hear that we hear a lot on the commission from the chief and probation, that they are responding to statutorily to that their hands are tied. And I'm wondering if you could just dig in a little bit more for us and the public about that idea.
Sure. So there's in the tool itself, there are certain reasons for detention that are not statutorily required, but that are determined based on policy of the department, that a young person who comes in with those offenses or conditions will be detained regardless. I don't have the LADs up in front of me. Maybe you all do, but I believe one of those categories that frequently includes overrides or mandatory detention are things like domestic violence and other issues where a young person can't go back to their home. There's certainly strategies for a safety plan or a release plan that could accommodate young people who are accused of offenses, that DV offenses, a whole host of other mandatory reasons that there's not an investigation further around what could we do, what kind of safety plan or release plan could we come up with for this young person so that detention isn't the default. And those are places where things like a DDAP type program, where rather than just going through a checklist and checking the box if a young person meets one of those mandatory criteria, we're going to detain them. Really having someone who's dedicated to thinking through what are the what alternatives are available that we can think about to not detain that young person. But I think it would be great for this commission to unpack those mandatory detentions and to get a report that looked at on a regular basis, sort of broke down which of these young people are held based on a risk score, and investigating that. Like I said, I don't think that a high risk score should necessarily mean that they're always detained. But for low and medium scores in particular, if there's a discretionary override reason, what is it and what can we do for a release there? And if it's a mandatory policy, what is driving that mandatory policy, and what can we do to to expedite release for those youth as well.
Thank you for those suggestions. Any more questions or comments? Commissioner Kakani?
Okay. Just a question about the SF DDAP program. Is that a separate branch within SF San Francisco's probation department, or is that like a separate
It's a
county
separate
department?
It's a separate, it's a nonprofit organization. It's Center on Juvenile and Criminal Justice. They have mentors that partner with public defenders and come in immediately to help build a plan for a young person to be safely released from detention.
Got it. And then present that to the court.
Yes, present that to the court.
Okay. And then as it relates to overrides, do you know if there are
Mhm.
any other counties, probation departments or courts or whoever it is that shares kind of some of this data? If there's like a dashboard that we could look at as a model?
I don't know off the top of my head a dashboard that's a model, but there are definitely counties that share that information regularly. Many, Lisa, when she came to talk to you, she was representing the Annie E. Casey Foundation, and they've done a lot of work with risk assessment instrument tools, in hundreds of counties across the country. All of those jurisdictions collect data in a really strategic way that look at the number of young people who are detained, the reasons for their detention, the override rate, and all the reasons behind it. So, and deliberate on that as a collaborative body that includes judges, probation, community, so that everyone can see the data, raise alarm when there are high override rates, and collectively think about what can we do to reduce this population, because there's, everyone sort of collectively agrees these kids don't need to be detained. What can we do to strategize around reducing that? So absolutely, it is a standard to be reviewing that data publicly in all of those jurisdictions.
Thank you.
Thank you. Any more commissioners? Okay, now we will move on to a presentation from probation. We have Director of Intake, Cesar Mayer-Queen, and Deputy Director Jocelyn Roman. Thank you.
Good morning, commissioners. The first thing I'd like to say is thank you for giving us the opportunity to respond and to have a robust discussion about our intake process. We have been here a couple of times to discuss our intake process over the last year, and one of the concerns is that we're still talking about the same data, right? We've made a lot of changes over this period, and we're still going back to the data that brought us here to begin with. So some of the data that we're looking at is 16 months old. So changes have occurred. We do see differences. Some of the recommendations have already been implemented. So actions have been taken to show that we hear you and that we see the concerns and we want to be proactive instead of reactive. The suggestions that were made, one of them, or one of the concerns, was about 0 CDP recommendations and some actions not being taken at the front end. What the data was not being collected 16 months ago was our cite and release. The fact that we have law enforcement contacting us at the facility immediately, asking us if this would be a youth that we would detain based on the facts. So we have a lot of youth that we turn for citation that don't end up coming to the facility. Therefore, you don't have anybody getting turned away because we've already had that discussion with law enforcement. We saved them the trip from coming to the facility and making sure that we screen it at the front end. We've brought that up a few times, but that would explain some of the data that we see is that proactive. That was not being captured 16 months ago. It is being captured now. It is one of the things that Mr. Marroquin implemented. Another thing that has been brought up was about training and auditing. Those are wonderful recommendations. Mr. Marroquin has been very proactive at doing that, really capturing maybe who needs a little bit more training. I've gone down there to see their processes. I've asked to be trained a little bit on their processes, see what recommendations I personally have coming from my level. I do see that they are proactive. I do see the engagement. I do see the discussion. Again, we're always open to recommendations, but capturing the data is what has helped us make some improvements in those areas. Lastly, the standards, we have to also we have to look at that it's not just data driven. There are cases where maybe the youth wouldn't be taken into custody, but the victim is living at the household. And now that youth cannot be returned to the home. And because we have no other option, there is no other family to come in and take the youth, we end up having to take the youth at that moment. That would be a youth that we wouldn't take into our custody, but because of the circumstances, they may have a low risk score, but we end up having to take them at that moment because there's nobody else to release them to. So there are cases that we have to look at. We definitely don't take a blanket approach to our youth, but that could explain some of the numbers that we see. I would like Mr. Maraquin to explain more in depth some of the changes that he has put into place, some of the recommendations that perhaps we don't align with, but most certainly we are happy to be here and we're happy to be able to have this discussion. Thank you.
Thank you, Ms. Roman. Thank you. Thank you for having me over, and I appreciate the information that was provided to us, and Ms. Roman for inviting me up here. So IDC has done a lot of work within the last year. We have, looked at the intake process. We worked with other, agencies and talked to police agencies and discussed what is it that they're lacking. So one of the main things that we really did, which I think is a positive thing, is we established a detention criteria, which was already introduced to the POC and to the public. However, this revised detention criteria basically illustrates what is a mandated detention. So part of our IDC process involves a phone assessment prior to law enforcement bringing the youth to the facility. In that phone assessment, we're looking at the charges and the circumstances related to the youth detention or arrest. And during that process, our officers are basically asking questions, interviewing the officers, like what role did the youth play in this crime? And they're also researching the actual charge to see if it falls under our detention criteria. Because we're actually vetting a lot of these cases prior, a lot of these youth are actually diverted from going to juvenile hall, which is a very positive thing that we've been doing. Fortunately, like Ms. Roman said, we weren't tracking that information in the past, but we are actually doing a very good job in tracking that information now. And we're, from the months of September through December, we were averaging about 77, we call them field site recommendations. In other words, we talk to the officers, we say, hey, look, this youth, most likely, we're probably going to end up citing them out. We're not going to, detain the youth in juvenile hall. Do you want to use your resources to transport the youth over here? And a lot of times the officers will say, we're going to cite the youth. We're going to cite them here in the field, which is a good thing because we're actually diverting the youth from coming to the halls. But those numbers have increased. I could say that even in January, we had over 100 field site recommendations. We had 85 in February. So when you look at the big picture, those are the youth that are being diverted from being detained. And when we look at the youth that are actually coming into the halls, those cases are actually being assessed, investigated. We contact the parent, we look at the police report, we look at all the circumstances, try to get school information, and we try to make a recommendation whether to actually detain the youth at intake or release the youth at intake. And we could release them on CDP, or we can also even opt to cite the youth out. But because we have an established detention criteria, the majority of the youth that are actually coming to the halls are most likely going to be detained at intake because we've already assessed those cases. And so we complete the investigation report, what we will call a detention report. And in that one detention report, we are actually doing two things. We are indicating that we detained the youth at intake, and we're also making a recommendation for the court. So the youth will report to court, will go to court in 2 days, and the judge will use our detention report to kind of, see if they're going to release the youth on CDP or if they're going to continue to detain the youth. And, we're being very subjective, but also trying to do it within parameters to say, okay, we're utilizing the LAD score. So if the youth scores low on LADs, we're trying to do a report where we're actually trying to be subjectively and within the parameters to basically recommend CDP. However, there's certain charges where, we feel that it needs more additional judicial review and the youth, we will recommend for the youth to be detained. And those might be the more serious and egregious charges that the youth have. Ultimately, I've had contact with one of the judges, and ultimately the judges make that decision in court. So when the youth goes to court, they're presented with our report. They're presented with a case by the DA, and they're also presented by a case with the public defender. And there's other issues or other circumstances that might mitigate the youth to be released at court, or the judge might say, you know what, I'm going to continue to detain the youth. So once the youth goes to court, the court makes that decision. Really, that decision is really not, it's out of our discretion. What I'm doing with IDC though, and this is something that we've been working on, is quality of our reports, trying to make sure that we're being thorough with the actual investigation, asking the right questions to the parents, trying to make sure that we're actually trying to present a nice, clean picture to the court. And also, one of the things that was recommended, which I see in the reports, is recommending to include the LAD score, is something that we've already been working on. And so at this very moment, I've been working with our IT department to kind of include that LAD score with the report. And that's something that's been discussed since last year. So we've already been working on that. As far as the, so when a youth is detained, so if a youth is presented at the detention hearing and the judge decides to detain the youth, at that point, there's a more in-depth report that's requested by the judge, and that's what we call a pre-plea. And what that report is basically like a social study of the youth, which looks into the youth mental health, school, other situations at home, gang involvement, substance abuse. And so that social study, which what we call a pre-plea, is presented to the judge within 10 days. So in 10 days, the judge has another opportunity to kind of see if we're going to release that youth at the pre-plea hearing. That's beyond the scope of IDC. We've already done our job at the 2-day detention hearing. But what I'm trying to say here, there's other opportunities for the courts to release the youth at that point. And of course, public defender, the district attorney, and other parties are involved in that hearing, including probation officers, because we're the ones that actually generate that report. I'm not trying to deflect the fact that that IDC is basically trying to push everything to the pre-plea hearing. But what I do want to say is that we've made a lot of changes, including the way we collect our data. We've made a lot of changes in the way we're actually trying to do the reports. We are developing a training for our officers, which was brought up, I believe, in September. What are we doing as far as training the officers? We have reached out to law enforcement agencies. I met with the Police Chiefs Association and presented the new detention criteria, which pretty much kind of shows everybody these are the youth that are going to be detained, and these are the youth that we're not going to detain. So I think we've done a lot of work, a lot of good work. And of course, more importantly, we're actually documenting and recording the field site recommendations. So we're tracking those names and those cases as well. So that's a good opportunity to kind of look into see what will happen in the future with those youth, because when there is a field site recommendation, the youth gets cited to go to court in 60 days. So what is the youth doing in those 60 days? It's a good opportunity to look into that. But of course, I'm thinking ahead. I'd like to say that, since I came to IDC in April, I think I've done a lot of progress in trying to do things right and doing things in the right direction. So, I think that's pretty much all I got to say for now.
Thank you. Commissioners, do you have any questions or comments before we move on to OIG presentation? Yes, Commissioner Terry.
Hi, I had a question about the 10-day reports you just referenced. I don't know if you can say this, but how often do those reports result in a different type of decision being made or release or an alternative recommendation?
Unfortunately, I don't have that data with me. That's pretty much handled by a different operation. So yeah, but every youth that's actually detained at the detention hearing, the judges usually, I would say all the time, order a pre-plea report. And that's because the youth is going to proceed with the case, and they want to know what's going on with the youth's dynamic, with the situation at home. And of course, I mentioned some of the other areas. So I don't have that data, I'm sorry.
Yeah, I mean, I brought it up because I know, like within DCFS, who has a similar report once a child is detained, that report is kind of just reinforcing the initial detention decision. So I was trying to understand, is there something, thinking of the previous presentation where there's like opportunities for off-ramping out of the system? Is that 10-day report one of those opportunities or not? So that's what I was trying to understand. I know you may not have the actual data.
So I could tell you one of the things that I observed was when we are doing our intake phone calls and they call their attorney, it's an automatic, don't talk to probation, don't say anything. And so that makes it a little hard to get information to put into that initial report about school and about everything else. Parents are a little bit in shock over what's happened. So to gather the information that's a little bit more robust at that initial report is hard. But that 10-day report, we might be able to have more conversation and have more details that we could include on something that could be a mitigating factor, such as, school attendance or something else.
Yes, Commissioner Mundo?
So just to that point, some of the IDC officers are very skilled at getting that information from the parent, and some go the extra step and call the school, so that helps. But I have a question, and I don't know if you remember this, Ms. Roman. We used to have an accelerated juvenile investigative team. And that was a probation officer that sat in the court building, and the judges were able to assess a case quickly and say, this kid's probably not going to go to camp. And that probation officer who had the parents in the corridor, had the youth in the back, would actually do the pre-plea within 3 days. And that kid will come back within 3 days and usually was released. Is that something that the department would think about returning to the fold?
I would say we're always open to suggestions and things that we could do differently. One barrier that you obviously know is the realignment that we've had with our staff. So doing an accelerated program would require obviously resources. But I think that's a conversation that we can definitely entertain. I don't recall that,
Yeah,
but
Mr.
I'd be open to more discussion about it.
Yeah, and IDC, actually, it was Los Padrinos, which had a high number when the courts were there. They had two of them, Mr. Blakely and someone else, but that's something that I've wondered if we can bring that back. And that would really reduce the number of days that kids are staying in the hall, so.
Thank you.
Yes, Commissioner Ship?
Yeah, can you get into a little more specifics around the training and auditing and like your findings around that? What has been the reason that more kids have been staying, and then how have you trained against that? Has it been bias? Has it been not knowing the facts of the case, or what situations have arrived, or just a little more on that training and auditing?
So our officers pretty much are following an established detention criteria. So if a youth is basically, slated to be detained at intake based on statute or a court order or even a probation policy, they're pretty much already making that decision when they do the phone assessment because they're falling under that detention criteria. However, when they're actually doing the report and they're actually interviewing the youth, and like Ms. Roman said, a lot of these youth will invoke their rights, so they opt not to talk about, their situation at home or anything related to like school or anything. When they invoke their rights, they basically are invoking the rights to talk about the actual case. But a lot of times, they'll be instructed not to talk about other things. So a lot of times the youth will not discuss what's happening. So a lot of the investigative work involves the interview with the parents. And so we try to get as much information with the parents. So our officers who have been part of IDC have been there for a very long time. They've been, officers, and we have very few new officers. And those new officers who have actually coming into IDC, who have been, I think we've only had two fairly new officers, had one-on-one training with the officers that have been there for a very long time. We're utilizing the established detention criteria. I mentioned that I'm trying to establish a training where the officers will actually have more investigative and training where they're going to ask the right questions as opposed to just going, and just jotting down information. So when I mentioned training, that's something that I'm actually trying to work on and create, and hopefully we'll get something rolling by the end of the summer. But yes, most of the officers have been individually trained by supervisors who have been there for a long time, by officers who have been there for a long time, and they actually not placed online live until they feel that they're ready. So aside from that, you talked about the quality. So what we're doing, we're pulling cases on a month-to-month basis. We're reviewing the cases and we're looking at the cases where the youth scored low on LADs, and we're looking at the recommendations, and we're trying to basically assess if, if the areas match, the recommendation. So if the youth scored low on LADs and you see a lot of positive risk factors, but yet they recommended continued detention, we're really looking at those cases and scrutinizing them. I've been meeting with my supervisors, and we're just pulling the cases, reviewing them, having a second look. And of course, the first line of defense is the supervisors who are signing the reports. So part of that is ensuring that they're following our policy, ensuring that they're following the direction that IDC is moving towards, ensuring that they're looking at the LAD score, ensuring that they're looking at all these other areas when they're signing off on the report. So that's the first line of defense as far as the quality. Now what we're doing is actually doing a second look, and it's something that, that I mentioned, I think in December, is that's something that I was hoping to roll out by the end of March, having something established and written down. But of course, and working with some of the other stakeholders in some of the areas that they found mistakes in, obviously, I take those, serious, and we're actually looking into fixing those mistakes. So I acknowledge some of the errors that may have occurred in the past. And we're hitting it, head on to try to correct those issues and try to provide the right training to make sure that the youth are, well, not the youth, but the staff are actually making the right decisions and actually identifying and checking off the right risk factors.
Thank you. Commissioner Mundo, did you have another
Just
question?
one question. I'm having a very difficult time squaring the 0 recommendations for release or CDP, that all 131 were detention. Is it possible, because on the detention report, you have a section on the front page that gives the recommendation. It'll say detention, but on the release page, on the final page, they actually check off CDP. Is it possible that there were more, that there weren't 131 straight detention recommendations? It does not square with the data that I've seen throughout the years. There's always about 10, 15% CDP recommendations.
Right.
So is it possible that the OIG might have missed that?
Well,
I
and
mean,
maybe,
we're able to look at the 131 reports and verify that on all 131 probation recommended detention.
maybe it would be also more helpful if we went ahead and let OIG present, and then we can ask back probation questions and OIG.
Okay.
So, yes, okay, go ahead. Thank you so much.
Good morning, Commissioners, Chair Canales. Thank you for the opportunity to be here to present on this. I first want to say thank you to Wendy and the PLC staff for their assistance in us providing this report. It's obviously, as everyone knows, it's a very vital and critical point in the juvenile process. So we were very encouraged to look at this area and then also to work with the PLC and their office, as well as with the probation staff. We had some very good meetings in relation to this report. I think Ms. Rodolfo hit on a lot of the areas that we may have discussed, and I think Mr. Mayorkin has addressed some of the recommendations, but I'll allow Fritz Lacey here, who was responsible for the report, to provide some detail in some other areas if necessary, and then obviously to answer any of the commissioners' questions.
Thank you, Eric. Good morning, everyone. That's right. Good morning, everyone. Frederick Lacey from OIG. I would offer an answer to the commissioner's question regarding the number of actual detentions. Our report concluded that there, out of 135 cases, there were 0 actual detention, zero actual release recommendations. That does not include the CDP recommendations. There were 51 CDP recommendations of that group that we looked at. The importance of the detention report cannot be understated or overstated, because the court, that's what the court looks at to determine whether they're going to release the youth upon the first court appearance. Our report dealt strictly with the detention report. It didn't deal with the IDC release at the initial arrest. The reason that it's so important is the courts really rely on these detention reports. It's almost like a rubber stamp at certain points. I was a public defender for 22 years and spent much time in the juvenile courts. The fact that there is no objective report within the detention report is very important, in that the court doesn't see any objective report, the DA doesn't see it, and the defense attorney doesn't see it. So as a public defender, we never saw the LADS report or any kind of Christberg scale report when we made our arguments for release. So the court was relying 100% on the detention report and whatever we could add. Our report focused on 6 cases that we chose as a sample. Those 6 cases were youth with the same charges, with the same socioeconomic background, and of those 6, 3 were released on CDP and 3 were not. The reports were written by 6 different probation officers. And I think that in and of itself illustrates that there is some inconsistency in these reports and the recommendations that are made by the probation officers. We actually went and got the LADS reports for those 6, and 2 stood out in that they had the same LADS score, same charge, same background, and yet one was given CDP and one was recommended detention. We have recommendations at the end of this, and I would state, first of all, we did spend a lot of time working with Mr. Marroquin and other people at the probation department, and they were very receptive to our report and to our recommendations. I think the most important recommendation is the importance of having an objective report that all parties at the court appearance for this detention hearing have and can rely upon and can argue for or against. Without that objective balance to the subjective detention report, I believe that the court and all parties do not have a full picture of the youth and of the importance of either releasing the youth on CDP, releasing the youth without CDP, or detention. I think that the importance of the probation officer keeping statistics on all this is invaluable. I think that they, since this report has come out, and even before, they have adopted a lot of our suggestions, our recommendations, and I believe that eventually there will be some type of objective scale, objective report put into the court file so that everyone knows that and everyone can argue for or against it. So I think that's about all our report has. I would also say that our first speaker went through the report pretty in detail. If you have any questions, now's the time.
Thank you, Commissioner Rondon. And then Commissioner Harris.
So your example is pretty simple. They might be charged for the same offense, but the role and the act and the offense can be completely different. So I find that lacking. And you looked at 131 reports?
I think it was 135.
Okay, so there's a triangle in the report if you're really assessing them. There's the LADS, which the officer has to identify certain risk factors. Then within the report, you have the different modules, right? They talk about school, they talk about parent at home. Then in the end, on the last page, there's a checkoff list of why or why not release the kid, correct? In your report, did you check if there was a correlation with all three? So if the officer put a 3 on drug use, did you go into the drug use section of the report and see if that 3 was explained?
Well, we spent a lot of time going through the reports entirely. Our focus was to determine the similarity of the background of the youth. We focused entirely on gun cases. So it was possession of a firearm. So that was the focus of the case. As far as going through individual sections and comparing it to other sections, we did not do that. We were focused on the difference between the youth in the 6 test cases that we had.
Okay, yeah, so.
Oh, go ahead. I was gonna say, I thought you were done, and I was gonna say,
No.
Commissioner Harris.
My question is for Mr. Marroquin and Ms. Roman. Are you willing, is the department willing and able to adopt the recommendation of the OIG and Ms. Rodolfi to include the LAD scores in detention reports? And if your answer is no or maybe, what are the barriers to that? And what are ways that you could remedy them so that you could adopt this recommendation?
Get that? Yes, we are actually, I mentioned earlier that we are in the process of already adding the LAT score. I think it's an important information for the judges. I will say that I met with the presiding judge and he agreed. And I think we're all the stakeholders here, including the judicial officers, probation. I think it's a good move for us to start including the LAT score. So my plan is, I'm already working with our IT team, so our ISB team, who are actually working on including that. And it will be included as a module in the report, so the courts will be able to review the recommendation and they can actually look at the LADs as well. My plan is to basically train and provide educational material to the judicial officers so they'll know how we're coming up with that score.
Would you also provide training and a sort of guide to it to the defenders and the DAs as well? So that
Absolutely.
everybody, okay.
Yes, absolutely.
Yes, Commissioners, Commissioner Kakani?
Do you have a timeline for that? Because I think I heard you say that that's been being discussed since last year around including the LADs in the report. So just wondering what the timeline is, if it'll be another year, a couple months.
So I've been working with the IT department on revising how the report is actually written. There's been some areas that I found last year that where the court report writing process was misleading for the officers. So I've been working on cleaning. Oh, I'm sorry. My apologies. Yes, I did bring it up last year. I have been working with our IT department and making some modifications on the court report writing process. Fortunately, because I've been doing that, I'm able to slide in the LADS score in there because it's already in the works of, we're going to call a modification to PCMS, our internal report writing system. And so I don't have an actual timeline, but I'm looking at earlier this summer because, everything that we submitted last year was probably in October. And we usually look about 6 to 7 months before it actually gets input. The LAD score, obviously, before it goes live, I will provide outreach to the judicial officers, the public defender's office, the district attorney's office, and provide training and educational material on how we're deriving that number. I also mentioned that last year that we were actually in the process of revising the LADs. And so that's another area that's actually, I guess I was thinking of doing it all in one shot. When the new revised LADs comes, we're going to include it. But I feel now it's probably in the best interest to start including the LADs before the actual revised LADs comes in. So that way everybody knows how that score is being derived.
And the timeline for revising the LADs? Because that's been obviously part of the Department of Justice settlement, and it's
Yes.
been an outstanding
Yes.
issue for some time. So what's the timeline for that?
I could say that it's pretty much already 90% completed, and it's actually at the hands of our executive team to review the revisions and review the actual report. Once that gets out and our executive team approves it, we're going to proceed and move live with that. So.
Okay. Just a few more questions. In addition to Welfare and Institutions Code 628, I know the department has a number of like internal policies around mandatory detention. Can you remind me what those are? I think there are like 3 that are separate from the Welfare and Institutions Code.
So 628, so you're asking about the actual detention criteria or?
If I recall correctly, you've presented before where there's Welfare and Institutions Code 628, and then there's some like probation, like LA County Probation Department, mandatory, again, not mandatory by way of law, but mandatory by way of the department's decision, detention criteria. I thought it was like possession of a gun. There were like 2 or 3.
Evading arrest,
What was it?
evading arrest. That was the apps list.
So 628 really touches bases on 3 factors. And one is the youth likely to flee jurisdiction?
No, I'm aware of those 3. I'm just,
Okay.
what are the probation ones?
So the probation ones basically are an in custody transfer from another county. So if a youth is actually detained in a different county and they're coming into IDC, we still have to do a detention report. We could recommend release, because we still have to do an investigation on those reports, but those are automatically going to be detained. So that's one example. We also have suitable placement runaways. Those are automatic detentions for the safety of the youth because they ran away from their placement, and they're actually not, supposed to be with the parents, guardians. They've been removed from the parents at one point. So those are automatic detentions. We also have firearms that we talked about, and that's a big one. That's longstanding policy that we've been detaining those youth if the youth is found in possession of a firearm. And another example, the other ones that kind of lead into the court orders are like 777s, which are violation reports. But those have to go with a director approving a detention, and it has to be vetted through me, the IDC director, to make sure that we're and also with the superintendent to make sure we have the space and the real estate to house the youth. So we really have to look at all the factors when we're looking at the 777s. And we also have CDP violations. That's a big one. So we have courts who are ordering the youth to be detained on first offenses. And that's kind of leading more into the court making that decision.
Okay. In some instances, it seems like those would be overrides of the LADs, for example. And I think it would be really helpful for 2 data points to be collected. One being the number of times the detention report, I guess, recommends detention or ongoing detention versus the pre-plea report. And I understand that that's a different, I think you said operation that handles the pre-plea report. But I think seeing the correlation between those 2 numbers, especially once you have additional information and how the department is moving, would be super helpful. And then the second data point I think that would be really helpful is like overrides. I think Ms. Roman shared something about a victim being at home, so low risk score, but no one to release to, right? And so obviously that feels like it falls within 628 in that there's an urgent necessity for protection of the youth or another person. But I think just understanding where the department is deciding to to override the LADs and what policy exists around those overrides would be super helpful to see. And I feel like I keep hearing this reference of we're collecting lots of data, but just a list of what those data points are and what they're telling us would be helpful because otherwise it's just words. So I don't, if it's overrides, I don't even know. Because I do think the Office of the Inspector General's report was really telling that when you have 6 gun charges with similar backgrounds and really different recommendations, like we should be looking at some of this data. And I do just want to share that Commissioner Harris and I had the opportunity to speak to one of your IDC officers at LP, and it was really enlightening I mean, he said it takes a couple of years to get really good at this. And it is to some degree subjective, and it is, unfortunately. And sometimes, a cop might say there was a firearm, and so then it's a mandatory detention. But he said, you might not know to ask, where was the firearm? Was it in the car? Was it on the passenger seat?
Right.
Was it, right? And so it results in really different outcomes for young people, which could include detention, which we know is inherently traumatizing and harmful. So, okay, with all that being said, I'd like to make a motion to collect that data that I just requested. I can say it again if it would be helpful.
Thank you so much for that. We do need to move on to public comment, though.
Okay, so I would like to make a motion to collect data that compares detention report recommendations to pre-plea report recommendations, to collect data on overrides, so when they're made and for what reason. And I feel like I said one other thing that I'm now forgetting. Oh, and if we can, whatever data that Mr. Mayorkin is collecting that's been referenced to repeatedly, I think it would be really helpful to, I don't know what those data points are, but whatever data is being collected, I think it would be helpful to.
We've
have a
been getting
better-
data.
I'm sorry?
We've been getting a lot of the data points. We know what the override numbers are. We don't know why the overrides are there, but we get that data.
Oh, okay, well, I don't get that, so, but if we could get the reason for the overrides and, yeah, if there are other data points that are being collected by IDC, that we don't already have access to.
Just to clarify also, the pre-plea may be based on a different charge than the detention. So that's going to have to be separated out.
You have plenty of staff to do that.
Yes. Would anybody like to second Commissioner Kakani's motion or make friendly amendments?
I have a question. Did you want to add a time period?
I mean, even we could, if it feels easier or more doable, even just the last 3 months and then maybe ongoing. I mean, presumably those data points are already being collected, so it shouldn't be too much work to share that. So I guess from, what are we in April? I guess from the beginning of the year, and ongoing.
Second?
Okay, motion by Commissioner Kakani, seconded by Commissioner Terry. Are there any other motions before we proceed?
Okay, we will go to public comment. Thank you very much to all of the panelists. I will echo Inspector General Bates's comment about the collaboration between POC and OIG on this report, and thankful for the reports from probation as well. And thank you to Laura Rodolfi. So if you'd like to make public comment on this agenda item and/or on the motion by Commissioner Kakani, seconded by Commissioner Terry, which is to collect data comparing detention report recommendations to pre-plea report recommendations, and data regarding overrides when made and for what reasons, starting on January 1st, 2026 and ongoing. You can please come up to the podium if you're in the room, or use the little raise your hand function, or dial *3 on your phone. I don't see any public comments in the room. Do we have any online? Oh. Good morning, Thomas.
He's had his coffee.
Oh, it's water. I hate coffee.
We're in trouble.
Mhm. Right. Hello, Thomas Bell. Just listening to some of the stuff going on about looking into releasing kids, I just want to remember that the first thing that we look at is safety of the community. When everybody focuses on how can we get this kid released fast, how can we get him out quick. I think I heard the lady even say somebody with domestic violence about he shouldn't be locked up. Who in the world would say my child just committed domestic violence against me and say bring him back the same day? Why would you do that? How is that committing? How is that safety? How is any of that? And I think somebody said a gun. I don't care where the gun was found in the car. It wasn't there for show. It wasn't made of water. It doesn't have water in it. Guys, we got to look at the safety of our community when we look at these kids. I don't know about the risk assessment. I don't do that stuff. Well, kind of do it, but not in his level. But I know safety of our community. When these kids get released, they go to the same school my kid goes to. When they get released, they go to the same neighborhoods my kids live in. So that's the first thing I look at. Is it safe to release them? Not if, oh, I don't want them in our juvenile halls. And second, I keep hearing about the racism part. I don't like bringing up the race part, but you guys remember, when they come to us, it's not about race anymore. We preparing them to go out back into the community. The racism part happens when they get locked up. So you guys go to the sheriffs, you go to LAPD, you go to these city police officers, and you bring that up. But as far as accusing us, a department that hires majority Black and Latino people to work for it, we focus on getting them out and put them back in the community. Maybe we should look at why our department is so scrutinized because we hire mainly Black and Latinos. Maybe that racist part we should look into too.
Good morning.
Hello and good morning. My name is Adedayo Adefarkan, and I'm a probation officer, and I'm also part of Union 685. Let's just be very clear. If we're going to be serious about reducing youth incarceration in Los Angeles, then we need to be honest about where those decisions are actually made. Probation officers do not create the pipeline to detention. We do not make the arrest, we do not file the charges, and we do not issue court detention orders. Those decisions are made long before a young person reaches us at these facilities. So when probation officers are blamed for high incarceration numbers, what is really happening is that the line staff are being used as a convenient target for much larger system failures. If the county wants different outcomes, then leadership must focus on the front end. Sorry, and just a little bit passionate about this because I'm one of those newer officers that you all are talking about. Prevention, diversion, mental health responses, community-based organizations, and court practices. The county's own data reflects already shown large numbers of youth that have been referred to diversion alternatives, which proves that the path forward is a broader system reform, not finger pointing at probation officers. Probation officers, we are the ground. We are on the ground every day, trying to keep the youth, the staff, and the facilities safe while carrying out the policies that are created above our pay grade and our pay level. We should not be scapegoated for problems that we did not create. We should be included as part of the solution because no reform will succeed if it is built on blaming the very people that are tasked with implementing your orders. Thank you.
Good morning.
Good morning. I'm Taliba Coffey. I am on the e-board of Local 685. I'm a probation officer as well, 28-year veteran. I want to bring up some stats that we received from August. We did, August 2024, we did ask for updated stats, but we didn't get that. So to start off, the Los Angeles County juvenile halls and camps and secure treatment facilities hold only minors, 66% of the population, and young adults, 34% of the population, whom the courts have determined are unsafe for the community supervision and detention. So in breaking those down, 31% of the youth that we have in LA County facilities are in the facility for murder, or attempted murder, including 89 minors held for murder charges predisposition. 24% are in there for assault or battery, including assault with a deadly weapon or an automatic firearm and domestic violence. 24% robbery or burglary, including carjacking and retail theft, smash and grabs. 12% serious firearms and weapons related felony offenses, including shooting into an inhabited dwelling, bringing a weapon into school, and carrying a weapon in a public place. And 2% is sexually assault or related crimes. And keep in mind that some of these victims that are assaulted are children under 10. When we are talking about depopulation, you have to take this into factors. There are victims that we often in this room fail to recognize. What is safe for the victim? I don't hear that. Do you think if I had a cousin murdered, do you think I want that person to be out? No.
Good morning. My name is John Roque, probation officer, 38 years, well, 38 in April. Real quickly, so when you say oversight, I just want to say that no one's being supervised in the community right now. You got parolees, probation, adult juveniles, mandatory supervision. There's no supervision. Public safety is at risk, and I just want to warn really the public. Where are the people supervising? They're in the halls now. So you have an age group about 50 to 68 years old. We're in there. Our family structure was built on the field because they wanted to professionalize the field, right? That's why they wanted older people in there. So I asked that you ask them, put us back in the field to supervise. Real quickly, hiring. I think we had over 8,000 applications in 25. We only hired 88. So you have to ask yourself, what's going on? I don't think it's realignment. I think it's a purge. Let me just read you these points about how we're really trying to professionalize. Allow discipline to be based entirely on hearsay. This was on a board meeting about on March 27. Double probationary periods from 12 to 24. Double unpaid suspension time from 30 to 60 days. Limit the ability to challenge discipline and termination. And another one, add and make additional changes. How are you going to attract people to come to this job? How? Who's going to want to work when they read this at this job? So again, are we short-staffed? I don't think so. Okay, people just don't want to work here. And the other thing I have is just real quickly. Remember our mission statement: enhance, ensure, and effect. We're not enhancing public safety. We're definitely not ensuring victim rights. Definitely not doing that. There's no victim involved because that's the antithesis to this whole thing.
We are on the
And then
agenda
effective
item, sir.
outcomes, the effective outcomes. Again, probation officers provide effective
Thank you
outcomes.
very much for
CBOs
your
are-
comment. We are on an agenda item, and you can speak when we do take just open comment.
Hi, good morning. I'm Isabella with the Anti-Recidivism Coalition. And I just want to say that although I hear their concerns with depopulation and how that doesn't help public safety, I think both go hand in hand. If you just lock somebody up and you don't give them the tools to rehabilitate and also help themselves out, you are not helping public safety. They're going to go back, they're going to do the same things. They don't get the tools while inside to learn how to heal, amongst other stuff. Thank you.
So we have one public commenter online, and we're going to close public comment after that. It's call-in user number 5. You'll need to dial *6 on your phone to unmute yourself. We can hear you.
Yeah. Yes, good morning. Can you hear me? Okay.
Yes, we can hear you.
Okay. Good morning. Hi. This is Mel. And I just wanted to comment on something that was stated earlier as it relates to the assessments. It was stated that there were two separate individuals that basically had the same allegation. And why was there a difference? I just want to remind everyone that, everybody is different, and everyone has to be assessed and evaluated differently. So you can have two people with the same age, the same exact allegation, the same situation, but you have two different outcomes when it comes to an assessment. And that's similar to what's going on with the department. You know, we have employees and officers who are all being blanketed into one situation, but everyone has an individual situation, and assessments are needed differently when it comes to making the right choices for the individual kids that are coming into detention. And it's something that just didn't want to be lost, unless maybe if I misunderstood something, but each child needs their individual assessment, and they cannot have a blanketed approach just because this number matches with that number or this penal code matches with that penal code. And that was just something I just wanted to identify. That's all. Thank you.
Thank you. That's the end of public comment.
Commissioners, do you have any further questions or comments? Yes, Commissioner Ship, and then Commissioner Meredith, and then Commissioner Mundo.
Yeah, also, this just reminded me, can we talk a little bit about the situation at Campus Kilpatrick? Some of the officers talked about them having to do intake, and they're not trained intake officers, but being trained on that. So can you expand on what the situation is there or clarify some of those concerns?
Yeah, the officers, so the process is as follows. When when a law enforcement agency contacts our IDC unit at Los Padrinos Juvenile Hall, we actually assess the case over the phone. And if it's a female or a gender-specific youth, we will direct the officers to transport the youth to Campus Kilpatrick. The actual intake is actually done by our officers at Los Padrinos Juvenile Hall. So we're doing the actual assessment because we're actually interviewing the parents and reviewing the court reports. So in the process of the phone assessment, we instruct the officers to transport the youth. Campus Kilpatrick staff are made aware that the youth is inbound coming to the facility. And our officers have actually been responding to CBK to provide additional training so they can know some of the documentation that's required, some of the processes as far as the intake. So to that degree, yes, they're not really doing the intake. It's really the LP officers who are doing it, the actual intake. But we are providing training to the officers over there.
Thank you. Commissioner Meredith?
Yeah, I just want to point out that you're right. Each case has got to be assessed individually. Each case has to be assessed individually. I got that. But I want to commend 685 and the officers back there for sharing their points of view, which are also very valid that we overlook. And they are kind of the brunt of everything that's tossed out at them. They do a hard job working, trying to rehabilitate the youth the best they can. But I do agree that every case has got to be, and I'm going to go with, I think we should go with OIG's recommendations.
Commissioner Mundo?
Yeah, I've always wondered why the inter-county transfers are detained, especially the ones that have been petitions have been sustained for non-707Bs. Is that statutory, or is that something that we can look at and not detain that kid once they come here?
So usually that's driven by the courts. So like usually if it's an inter-county transfer, they'll probably see a court and let's say for San Bernardino, they're transferring the case over and the youth is already in custody. And so when the youth comes to LA County, we have to prepare a report because the youth is going to go to court for an LA County case. I mean, it might be a situation where the youth is on like on a warrant and he gets picked up on a bench warrant in San Bernardino, and so they're in custody already. So we still have to do a detention hearing. So most likely we're not going to release that youth at intake because the youth is obviously like a flight risk. He's in a different county. There is other situations where I do want to point out that we have like courtesy holds. Like we have youth that are actually in warrant, have a warrant status from like, let's say Fresno County, and an agency here in LA County picks up the youth because the youth is considered like a flight risk because they're in a different area. We have to take that youth in, but we do everything possible to get those youth out. So like those courtesy holds that I just mentioned, they get released to the probation department for that county, and we make an arrangement for them to come pick up the youth ASAP. But again, for the ones where they actually saw a judge in a different county and they're being transported to LA County to see one of our LA County judges, we do have to kind of really assess and ensure that the youth is in custody. But that does not mean that we cannot recommend, release or, at the court hearing or maybe CDP. So we are looking at all those factors. And again, every case is looked at subjectively. We're looking at
I guess I'm
stepping
just
every
asking
step.
about the ones that were detained in another county pending adjudication. Adjudication was completed and the return to our county of residence. And the underlying offense was a non-707B. Why can't we house arrest those or cite those to go to court since they were only in the other county because they were they were arrested out of county, our county. They're our residents. They're our kids, and they're not 707B offenses. I just wonder if that's statutory.
Well, that's something we could look at. So the thing is, if they saw a judge in San Bernardino County and they determined that this youth is an LA County resident, and they make that decision to detain the youth is already in custody. So we have to hold that youth till he sees our judge, but that's something that we can talk about in the future and maybe work on something, but I can't really answer to that. But that's something that we've been doing for a long time.
Forever.
Yeah, and it's pretty much our policy right now, so.
Just wondering.
Yeah.
Yes, Commissioner Terry.
I had a question related to the intake and detention analysis report that the POC staff completed, and I know the probation department issued a response. One of the questions was around, has the department continued to conduct regular case reviews in collaboration with other county stakeholders and partners? And the response was that the project was initiated in 2024 but had minimal success, so was discontinued. And I know the regular case review has been one of our kind of ongoing recommendations related to depopulation. Can you share more about how many cases were reviewed in that initial period and what does minimal success mean? Trying to get an understanding of what happened and why was it discontinued?
That evaluation had been conducted with Angela Walker's team. I believe we had come out to POC and talked about that. So we don't have the details on how those numbers were, but I think it was presented on previously.
And we do have Luis here in the audience. Perhaps he could answer that question better, if you don't mind.
I believe Commissioner Terry's question is about, there was a response by probation in the response to our report about the structured release program being discontinued, and because it was minimally effective, I think is the word that was used. If you could just share your perspective. I know you were deeply involved in that as well.
Morning, Commissioners.
Maybe happy to turn it on.
Hear me? Is that better? Okay. Good morning. The structured release has changed in formation. It initially started with the multidisciplinary teams that were brought together in addressing, before we even got to depopulation, dealing with more release of youth. What it's turned into now is that we will get a list from probation of a number of youth who they believe would benefit from what they call the ensuring least restrictive means. We get the list, and usually OIG gets a copy of that list, and how we respond, we go through every single youth that probation considers. Fortunately or unfortunately, with that list, the fortunate part is that the majority of those youth are being released by the advocacy of our attorneys in court, whether it's through the adjudication or a pre-plea release. And then there's other circumstances that unfortunately the youth doesn't qualify because it's a serious offense, it's a potential transfer hearing. So to answer your question, we continue to work through that, but it's not ineffective because of the process. It's ineffective because unfortunately the youth that we get are the ones we are already working on to get released. But probation has been very open. In fact, I had a couple of cases yesterday that were not on the list, and Ms. Morales from probation is the point person, I'll just send her the names and say, you know what, can we take an exception to this and do this structured release meeting? And they will. Again, it's not the perfect system, but we continue to work through it. And as much as we're able to, trust me, is that our attorneys try to take advantage of that as much as possible. And we've had some successes. Unfortunately, some of the times when we're asking for the release, especially for girls and gender expansive youth, it's very difficult getting a facility or a provider to give us a space for that person. So that continues to be a major problem in how we deal with girl and gender expansive youth in LA County, the lack of outside resources for them. I don't know if that answers your question or not.
Commissioner Terry, I thank you for that, Mr. Rodriguez. And I think that there are two different kinds of case reviews that are referred to, and the response from probation relates to the one that Luis just described, which is the structured release, less restrictive placement case conference, for lack of a better word. The other one is what was in the depopulation plan, which is the idea that Judge Espinosa presented to have the department review all of the cases of all the pre-adjudicated youth detained, and maybe even some of the post-adjudicated youth detained for the possibility of release. And the department, in its response to the depopulation plan, explained that they had gone through all the cases, and there was a very small number of youth who were released as a result of that case review. So I think the answer to the question in the report is regarding a former process that was just described to you, and the question was also related to the current process of continual case review, which is what Ms. Rodolfi referred to, is this idea that there could be continual review of the opportunities for release. So thank you for bringing up that question. I agree. It's referring to a couple of different situations that are being conflated.
Theoretically, though, every time a kid goes to court, your office is making an effort to release, right?
Correct.
So that's ongoing within the court and in some level.
Not within the court, but definitely within our office.
Within your office?
Yeah. But just so we can tell, and look, I've been very open to this, and I agree with some of the points that were brought up by the probation union representatives. The court has a lot to do with this as well. Okay. When they make an automatic detention order, it really ties us as to what we do. So there's another player here that is a key to what ultimately happens to our youth.
Well, on that point, I will ask this because it's been a point of contention for me. Is it possible for the public defender's office to kind of just collect some data that shows how that other player operates? I mean, I hear that that other player operates differently than the player before, and yet without the data, we don't know which player and how the player is playing. And it would be nice to know overcharging, overfiling, how many enhancements are charged in this county, how many strikes are charged, so we can compare them to other counties.
Without getting into the Bud Abbott and Lou Costello, who's on first analysis of the question, I can tell you that we continue. I won't disclose what we collect, but we do collect information. We have discussions with court leadership as to specific bench officers and issues that we have with them. And, we're trying to work through those things currently on a number of issues. So, yeah.
Can I ask a quick, what is the objection to making some of that like raw data public?
Objection to?
I mean, it sounds like, I think I heard Commissioner Mundo ask, like, you are in a position to collect that data, given that you have the most number of young people on your caseloads. And so like in terms of like when enhancements are charged, when, I don't even know when strikes are added. I don't even know all the language, but I just feel like the public defender's office, I know that it's like one county family and so it becomes complicated or whatever it is, but I think you all have a real opportunity to shed some light on what's going on. And it just feels like there's always resistance to sharing that publicly, even if it's just like raw data that's not tied to any young person.
Well, look, I disagree with your comments and your question. We're not trying to hide information from you. Our main goal is always to protect our clients. And whatever information we retain, we do it for the purposes of how can we better deliver services in defense of our clients. And so sometimes reports are prepared because there is a request from a collaborating agency. We'll prepare and provide that information. And other times we'll prepare information for our own internal administration of our services and our personnel. But I'm not going to sit here and try to convince you that we're not hiding information. That's not my job. My job is to make sure that we provide as much support for our staff that we can. And sometimes that includes gathering certain information that we're not going to share because we believe it's attorney-client privilege, work product that is protected. And so that is a major concern that you're an attorney, so you should know about that as well. So to answer your question, we will definitely share information when we believe that it's ethically permissible and it goes to the greater benefit of our client. But I'm not going to sit here and argue with you as to the policies of our department.
So it's interesting. Let me remind people who came into the juvenile system first. It was the public defender's office, not the district attorney. And I don't think there's a county in this state that has a more adult operating system for juvenile than LA County. The number of days that our youth are in pre-dispo is unmatched. And it's just difficult to assess that if it's unethical to say that we had 30 kids arrested this month, and out of the 30, the DA filed 20 enhancements. I don't understand where that's unethical. We're not asking for the name of the kids.
I don't think this is Lewis's place to argue.
Thank you. All right.
The motion.
Thank you.
I appreciate you, Lewis.
Thank you.
Okay, so I'm going to call the roll for a vote on Commissioner Kakani's motion, which is to collect data comparing detention report recommendations to pre-plea report recommendations, as well as data on overrides, when made and for what reasons, beginning January 1st, 2026 and ongoing. So please vote yes, no, or abstain. Commissioner Harris?
Yes.
Commissioner Kakani? Yes. Commissioner Meredith? Commissioner Mundo? Commissioner Shipp? Commissioner Terry? Yes. Commissioner Canales, Chair Canales? Yes. So with 6 yes votes and 1 abstention, the motion carries.
Thank you. Okay.
Sure, yes, sorry. Thank you, everyone, very much for joining. We'll shift to our next presentation, which is on visitation, and the chief is here. So for those of you who are in our virtual audience, so we'll welcome him up to the panel. Thank you.
So now let's move on to agenda item 4, which is to discuss and take possible action on an update on changes to visitation procedures and adoption of a visitation policy by the probation department. Our panelists for this agenda item include Chief Villarosa, Commissioner Tyreek Shipp, and Project Director Dr. Gongora, representing the POC. And joining virtually from the California Office of Youth and Community Restoration are ombudsperson Alisa Hartz and Family Engagement Specialist Cole Lancaster. Attached to the agenda is OYCR's model visitation guidelines that were provided to us in December of 2025 and the POC's November 2025 report back on visitation inspections. Chief, can you start us off with updates on how probation has implemented changes to policies and procedures in line with best practices from OYCR and POC's recommendations? The probation department was asked to provide an updated visitation policy and a verbal report on changes to procedures to enhance visitation. Thank you so much.
Thank you. Thank you for the opportunity. Good morning, but I'll
Actually, for this report back, I'll pass it off to Deputy Director, Ms. Roman.
Good morning again. With me today is Veronica, what's your last name, Veronica? Castillo. I want to make sure I say it right, Veronica Castillo. She worked with us on the recommendations that we had for visiting, some very collaborative work with OICR, with our team. So she's going to give some more in-depth discussion. Overall, I would like to say that this was a great opportunity for all of us to take a look at our policies, see what areas we could improve upon. We do have a policy that is currently in draft after our collaboration. My team has taken a look at it. We have a few more tweaks that we would like to make to it before we finalize. We did update the signs before anybody asked me about the Kulaks pants. It is not up there. We don't have to talk about it anymore. We are very, very, very happy to be here to discuss this and work on our relationships for our families and our youth. Ms. Veronica Castillo.
Yes, good morning. Good morning. Good morning, Chair Canales and Commissioners. Thank you for the opportunity to provide an update on the Los Angeles County Probation Department's transition to a revised visitation policy. This policy is grounded in family unification and allows for access to contact visits. I want to thank Executive Director Wendy Julian, Dr. Sarah Gongora, and Commissioner Shipp for their engagement and collaboration. They have been valued partners throughout our process of updating and revising our policy. In addition, this policy reflects the vital technical assistance and feedback from the team at OICR, Cole Lancaster, Mark Varela, Annie Selch, and Elisa Hartz. Thank you all for your integrity in the process and your patience. Evidence shows that involving families is a fundamental principle and highly effective strategy when supporting youth in at risk of entering the justice system. Meaningful family connections are one of the strongest factors linked to successful outcomes for justice-involved youth. This effect aligns with the Los Angeles County's broader youth justice and care first vision, particularly as the county continues to shift toward a model that prioritizes rehabilitation, equity, and long-term community safety. Historically, visitation within Los Angeles County Probation juvenile halls and camps has been largely non-contact, limited frequency, and constrained to logistic barriers such as scheduling challenges. These limitations have made it difficult for families, particularly those that live in geographically distant communities, to maintain consistent contact. The revised visitation policy represents a meaningful shift. With the approval of the Chief Probation Officer, it allows for access to contact visits. Youth will be able to engage in a hug with their visitor at the beginning of the visit and at the end with a structured and supervised environment. This change recognizes that human connection is essential to the emotional well-being and development, particularly for adolescents. The policy also brings forth a reasonable approach to the dress code. Often subjective applications of a stringent and outdated dress code has made visitation prohibited. The new policy is updated to allow for more flexibility with appropriate options readily available on site. In addition, the department has included a contingency to track visitation through a database that identifies frequency of visits per youth. What's important about this addition is that we will be able to identify and monitor youth who are not receiving visits. We'll work to identify the cause of the issue, whether it be distance, working hours, or the youth being estranged. With this information, we can seek to unity by problem solving and work toward unification. For those youth who have not received visits for over 90 days, we will partner with other stakeholders to identify a volunteer, a mentor, or a supportive adult to step in and visit with the youth. To support this transition, Los Angeles County Probation is investing in staff training and facility readiness. Staff are being trained to understand visitation as a rehabilitative tool that can reduce tension within facilities, improve youth behavior, and strengthen reentry outcomes. Physical spaces are also being assessed and, where needed, modified to safely accommodate contact visitation. This transition reflects a broader cultural shift within the department. It's about recognizing that family is not separate from rehabilitation. It's central to it. By strengthening these connections, we're not only supporting the young people in our care, but also investing in safer, healthier communities across Los Angeles County. The revised visitation policy is a critical step forward. It reflects data-driven practice, community values, and our shared commitment to a compassionate and effective probation system. Thank you. I'll be happy to answer any questions.
Thank you so much for that. Dr. Sarah Gongora, would you like to share about the POC's updates?
Thanks so much, Chair. So I just want to frame this for people that are joining us maybe online and haven't been able to follow this work as closely as we get to. So just as a reminder, last August and September, the Probation Oversight Commission conducted a number of visitation inspections where folks went on a Saturday or Sunday, either to Los Padrinos Juvenile Hall or to Barry J. Nydorf, and we really had the opportunity to speak with families and young people about their experiences with visitation. And because of that, we put forward the attached report last November, which made a number of recommendations to the department, including many things that Veronica has just mentioned, including updating a policy and applying it consistently across facilities, encouraging the department to get creative and solution-focused about how to get young people their visits by minimizing the number of visitors turned away for non-safety reasons. And overall, just to improve the tone and the experience for people coming to visit their loved ones in these facilities. So likewise, Veronica, you said a lot of thank yous. I also want to say a couple of thank yous. Obviously, this has been many months in the making, and there has been a lot of teamwork and group effort. So we are so thankful to Deputy Chief Arcos, who let us know that he couldn't be here well in advance of today, and who did take the steps to share the policy for now confidentially. It's still in draft form, and it's still getting ready to be published. So as soon as that is ready, we will be publishing that. But we're so grateful for all the work he and his team have done separately with the Office of Youth and Community Restoration to put forward this very model policy. And so I just want to say thanks to both Deputy Chief Arcos and OYCR for all their work. I also really want to thank the young people and the families. We show up, we ask hard questions at a very vulnerable time, and people open up. And this has really been a community-driven effort. And so I hope that if any of those parents or young people are listening, I hope that they really heard the things that they asked for and the things that they wished for in the report that Ms. Castillo just gave, because I believe I heard it. And I just also want to thank our commissioners and our POC staff who took the time on their weekends to get out and to really connect with the people. So I now would like to pass maybe the mic to Commissioner Shipp, who has been he is chairing the POC's ad hoc on policy, to make any comments perhaps or any reflections about this process.
Cool. Yeah, I mean, I'll probably just echo some of the same sentiments. The thank yous to everybody for this work, especially POC staff on this work. I think that their help on this has been invaluable. And then thank you to the department for taking this on. What I will say is that, that this work isn't over. This is just, a step forward. And I think it's a step forward in the right direction. And so I'm hoping in our next inspection or our next look at visitation that we do see the progress, because we see the progress happening. What I will add, and I don't think you said it, but one of the things probation did name to us in the meeting was that they have already started these things before the policy has been put out there. And so this is something that should be happening on the ground now, and I commend them for that type of work.
Thank you, Commissioner Ship. And before we go on to virtual guests, OYCR, I just want to say that I did visit Los Padrinos a few weekends in a row, and I noticed a definite shift. As a matter of fact, I even said it was weird. Like, it just seemed like, it was friendly and respectful, and just the whole attitude. I was talking to visitors, everything seemed calm, and then it just so happened that there was an actual incident in visiting with one of the youth, but the probation, the way she handled it, her tone and the de-escalation, and got the youth to really calm down, and even his family member that was right there too, as we walked out and talked about the situation. And then another father that there was some things going on, and able to see him the following weekend too, and seeing how probation handled that. And I made sure to tell them too, like, this is something that we have been working on, and I'm seeing, the change here, and thanking them. And so I just want to raise something that I saw myself while visiting and while seeing. And then another thing I want to just uplift is I have a dear friend. She was a lifer in prison, and her grandchildren are there now, but they had no idea I was going to appear that day. And to see her rapport with probation, and probation right away knew the youth and was like, we're going to call your grandma if you act up. But seeing that relationship, I think, is so important. And then commending him in front of the family was so important. And I know meant the world to her. Nobody wants to see their children or their grandchildren in these situations. And so that was really uplifting too, because that was somebody that I personally knew, and it meant a lot. And so, and I look forward to, the success of her grandchildren. And so now we will move on to our virtual guests with OYCR to see if you have any feedback or discussion on the visitation topic.
I think we're pulling Elisa and Cole and Mark's video up. Elisa, can you hear me?
Yes, can you hear me?
Okay, great. Yes, okay, we can see your faces in the boxes now. Please begin.
Excellent. Well, thank you so much for inviting us. I think we will start just by echoing all of the shared appreciation for this collaborative process, in particular for the openness of the department to engage with us on these really important issues. And we are continuing to engage on the updated policy. We're really pleased to see a lot of our feedback being incorporated, and always having robust discussions about it. I think once this policy comes into the world, it will be very exciting to see how it's playing out on the ground. And I'm glad to hear that those changes are already being showing up even before the policy has been finalized. So I will just turn it to Cole to just share a few of the kind of most exciting highlights that we're seeing in the revised policy, and then ask Mark to make any additional reflections.
Good morning. Yeah, just to echo what's already been said, I think we've been very pleased that LA Probation has shown significant progress towards the best practices we laid out in the OICR memo since last year. And I also want to shout out specifically Deputy Director Arcos and Veronica and the team over there for consistently both soliciting and accepting our feedback on these policy revisions in the month since. Just some broad level highlights that were really pleasing for us is they include a large amount of the best practices we outlined in those recommendations in that memo. Overall, the policies we've seen has been written in a much more positive and supportive tone that explicitly states the importance of family engagement and defines visitation as a right, not a privilege. And also it included positive revisions that we didn't even explicitly include in our recommendations, which really shows to me that the policy team over there is really looking to improve the experience. Um, Lastly, we noticed that the policies become much more conducive to an operational culture that supports family engagement. There's explicitly requiring staff to initiate and maintain communication with family, calling for staff to be flexible and work with and resolve issues with visitors to try to make sure that youth are able to get the very important visitation. So overall, yeah, very, very positive. And we're happy to continue working with that team. So I will turn it over to Mark if anything else he'd like to add.
Good morning, Commissioners. Mark Varela. I'm a justice consultant working for Just Solve alongside OICR and in support of OICR. Veronica's opening statement just said it all. Incredibly positive, very supportive, great understanding of the importance of family engagement and also prioritizing this in this particular policy. Chief Deputy Arcos, Veronica, the whole entire team have been very open, very responsive to the feedback that we've been able to give under the direction of the chief. The policy's moving in the right direction, and again, very, very pleased with the work that's been done. The meetings have been incredibly productive.
Thank you so much. So now with that, I'm sorry, I'm lost. Oh, Commissioners, do you have any questions or comments? Commissioner Harris?
Did I miss implementation? I know some of it's already happening, but do you have an estimated timeline as to when the will be revised and released and official?
The committee still had some feedback that we want to take a look at and be able to make some adjustments to it. So it's not far off from being finalized and implemented. But like they said, we've taken some very proactive approaches to make sure that we are moving it forward whatever we can.
Commissioner Kakani?
I may have not heard this part, but was there something stated about like minor sibling or like relative contact? I know the draft policy mentioned it, but just wondering if you could share kind of like where you see that going. Right now, I believe it largely lives with the court where attorneys have to make requests for special visits, but if you could kind of share where you see that heading or if that's the same model or, yeah.
So special visits are certainly part of our process and within the policy. The areas that have more room is camps, obviously, because the youth are there longer term, so we can actually establish some goals as part of the MDT process with family reunification and with the therapist. So those would not have to require court orders. They would be able to be more therapeutic in the approach, and they're already there. Within the institutions, within the juvenile halls, we do rely a little bit more upon the court orders because we need the verification as to who, the family members are, where we are with the siblings. So we continue to work on that, but it doesn't always require a court order for it to occur. We've done events such as birthdays, right? At Campus Kilpatrick, we just had some things where we were celebrating youth birthdays and they included family members. So we are open to different layouts and different ways of doing it. But again, we want to make sure that we're prioritizing knowing the dynamics of the family as we try to incorporate some special visits.
Yes, Commissioner Terry.
I wanted to just echo, I know at Barry J, the probation officers who I observed during visitation were so respectful to families. They were really taking time to call people to make sure people had information about visitation, if they could or couldn't come and what was the reason. So that was really great. One thing that I observed, and an officer I was speaking with also lifted this up, is that for those young men who have children, like small babies who they're visiting, it's kind of like a multi-purpose type of area that they're visiting with. So the baby's crawling around on the floor where other activities are taking place. And then sometimes the toys are a little old. Does the department have resources? I know space is an issue, so maybe there can't be, or maybe there can be like a designated space for babies. but in terms of even just kind of having updated baby-friendly toys and things like that, how often does that kind of thing happen where blocks, things like that are bought?
There's no barrier to that. I'm extremely passionate about baby bonding. So I'll find out what the concern is and what the issue is with Barry J. I'm doing a site visit next week. So I'll specifically go see the baby bonding area. I already have items that I can provide them with because we have already been proactive on that end.
Thank you. And I can verify, I know the one youth when we were in LP and he talked about his baby. And I called you over when I went back the next week. I'm like, did she come through? And he verified that, yes, you did. So I know that that is something that you're committed to and passionate about. And even the staff at LP, they think baby bonding is so important. And that's one thing that they raised. They said, if we could even get more baby bonding, we think that, that helps the youth, which of course. Commissioners, any more comments or questions? Okay, and with that,
Mention one
yes.
thing, just because I think I've mentioned it before. We incorporated Meet a Manager into our visiting once a month. So if you're not aware, we have an opportunity where we give out flyers and we have a manager from the facility on site available to answer questions for parents, guardians, anything that they may want to know. We try to advise them ahead of time, so if they need to make adjustments to their schedule. And it is a meet and greet, and it's an opportunity to be able to bring any concerns or even positive things to management attention. So if there's anybody that is not aware that that's occurring, please know that at every facility that is happening.
Thank you. All right, Wendy, do we have any written or live public comment?
I believe we do not yet have any written public comment on this. I'm looking at Janae. We do not. But if you want to make written public comment, email us at info@poc.lacounty.gov. Thank you so much to all the panelists and the commissioners for their work on this. Anybody in the room want to give public comment about the visitation item? I'm just going to please ask that folks stay on topic as we go forward. And if you'd like to make comment online, use the raise your hand function, and that's the little hand icon, or dial *3 on your phone. Go ahead.
Good morning again. My name is Adedayo Adefarkan, and I do work at Barry J. I'm a probation officer, and I'm also one of the union reps for 685. First, I want to thank you, Ms. Diane Terry, for making that acknowledgement at Barry J. We do respect and we appreciate families supporting the young men that we house at our facility. The baby bonding is absolutely important. Family bonding is absolutely important. And as probation officers, we support family visitation. But special visits is where I personally think, this is just me as one person, think is the arena where any kind of contact should be made. And I think that bringing in us as probation officers who are there, who are doing the work, who see the families that come in, because sometimes we have family members who come in who are very disrespectful, especially to female staff, and we won't tolerate that either. But inside the general visitation, I don't believe that is the right place. But as you said, in the special visitation, I think that's the proper arena to start developing, because we have to incentivize these young men to earn that kind of visitation. It helps them with rehabilitation. We support family visitation, but we strongly object to visitation that's going to create any kind of opportunities where contraband can be brought in. We want the exact same things that you do, but you have to bring us to the table as the officers who are doing the work. We're doing 16-hour shifts. Not only are we being held over, we're volunteering to be there. Then also include these young men. Let them pick the staff that they want to be with them during these visitations, because we build the rapport and the bonds with these young men. We are also invested in them as much as you are. But if we're not brought to the table, all of this is just being done as smoke. Thank you.
I'll introduce myself again, Taliba Coffee. I'm on the E-Board, Local 685, also 28-year veteran LA County Probation Officer. In regards to AB 1646, the HUG Act, I want to make it clear, as far as the union is concerned, we are not opposed to this. We understand that healthy connections with parents and loved ones can support emotional stability, reduce recidivism, and strengthen reentry outcomes. But our concerns are safety inside the secure facilities. And part of that is concern, our concern is contrabands. Contrabands have gotten into the facility some way, somehow, and we have to be able to monitor that. So right now, as you know, we're operating with a 28% vacancy rate. So we don't have a lot of staff that can do that. So we are opposed, we want to make an amendment to this. We're okay with the use having a hug in the beginning and in an end, but a prolonged, it really opens up the door for contrabands to come into play. And just to wrap it up, I want to let you all know, in case you all forgot, and some of the people in here tend to forget, Los Angeles County mother was sentenced to prison on Wednesday after she tried to sneak fentanyl into Barry J. Nardoff Juvenile Hall in Sylmar in 2023. Let's not forget that. Every parent is not going to do the right thing. Thank you.
Hello, my name is John Roque. I think we have to know how we got to this point. The reason why we're doing this HUG Act is because prior, we had a massive amount of contraband come in. Drugs, all types of contraband, okay? You gotta have the officer safety first. Then everything else will fall in line. I'll just read some notes. It says, staffing shortage making monitoring extremely difficult. Los Angeles County Probation currently has a roughly 28% vacancy rate among sworn staff. 2, deputies must simultaneously supervise housing units, youth movement, and facility safety. 3, many campuses house both predisposition minors and secured youth treatment facility of young adults, requiring careful supervision and separation. Also know that we are limited to how we search. You could do a pat search, but you can't search the pants inside. We could take them to a scanning if we really feel that there's something else, but we cannot remove their garments. So we can't do a thorough search. And that's the inability to make it safe and secure. I'm sure 99% are fine, but all you need is that 1%. Thank you.
Okay, we have 2 online speakers, and we will close off public comment after that. We'll start with call-in user number 6. We'll unmute you, and you'll need to dial *6 on your phone.
All right. Good morning.
Go ahead.
Yes, this is Mel again. Good morning. I was wanting to tap in and say, first of all, I think this is a great job, a great presentation. A while ago I had mentioned staggering visiting hours, and I'm glad to see that there is at least a split from the 12 to 2 and 2:30 to 4:30 approach. One thing I would ask for consideration is to possibly consider doing more of a staggering throughout the day. I think that would also allow if we can dedicate the day to visiting, then I think that it would require less officers for staffing purposes. And then you would also have the consistency with the those who are there, which actually would springboard into fostering better relationships with those who are making the visits. And then it also provides a more concentrated environment, just in case there happens to be an incident. We're hoping it doesn't. And it would also allow for family reunification in case you have parents or families that have multiple family members within the same facility. Of course, separate arrangements could be made as well. And then one thing I'm not clear on is are there any travel plans for parents? I know listening to the Board of Supervisors meeting, there seems to be budgetary gaps where we could possibly have that. So I don't know if there's any allowances or any allotted funds that are set aside to help parents travel. Or I don't know what the current status is of that. Thank you.
Thank you. And our final speaker will be Crystal Jones.
Hi, everyone. I'd like to take a moment to speak to the importance of revisiting the policy through a youth-centered lens. If we are truly committed to reducing recidivism and improving long-term outcomes, we have to be willing to examine whether our current policies are creating pathways forward or unintentionally creating more barriers. Many of our youth are navigating systems that are not designed with their voices, experiences, or realities in mind. And because of that, we often see compliance without connection and structure without sustainability. This is where youth leadership becomes crucial. When we begin to model accountability, consistency, and opportunity and invite the youth into that process, we shift from control to empowerment. We move from telling them what not to do to showing them what is possible. With Crystal Clear Academics approach, we are rooted in modeling by example, and we don't just provide services, we create environments where youth can see leadership in action, like our parole officer mentioned, practice responsibility, and build confidence through real opportunities. I believe policies should reflect that same philosophy. Policies should support not only supervision, but development, not only compliance, but growth, and not only outcomes, but transformation. And I think by revisiting that policy with this in mindset, we can create systems that don't just manage our youth, but truly prepare them to lead, contribute, and succeed in our communities. Thank you.
Can I ask a clarifying question? I just wanted to add, based on the question, and ask a question about the transportation on what Mel commented on. We were at Kilpatrick last week doing an inspection, and I asked a bunch of the young people about their experience with visitation. I was very happy to hear many of them report that they had received multiple visits, and I asked them how their family members were getting there, and the ones who had received the most visits, not surprisingly, have family members who have cars who were driving themselves to Campus Kilpatrick. But I did talk to a youth whose parent had used a Lyft voucher from Los Padrinos. And I'm curious if you could talk a little bit more about the interaction between those two things and how the department and CBOs and others can continue to help with that gas voucher driving, getting to Kilpatrick issue.
So the first thing that was mentioned is if we have a special fund for that. There is no special fund for it. We are working on it for our youth at Campus Kilpatrick currently, and it is being led by Mr. Jesus Corral. We are not giving out vouchers, but we are coordinating transportation. So the parents and visitors are invited to come up to LP. They have to be at LP by approximately 11:30, and they will be taken via a Lyft or an Uber over to Campus Kilpatrick. They will remain for the duration of the visiting time, and when it's concluded, they come back. We recently incorporated a system that also includes Dorothy Kirby transportation from there. So one of those two locations to go up to Campus Kilpatrick. The data is being collected so we can see what those outcomes are and see how we can build that out differently or if we need to expand it. Additionally, the team that Mr. Jesus Corral works with is making contacts to every parent over at Campus Kilpatrick, letting them know that this is an option if they don't have access. Being very, very proactive to make sure that they're aware of the service. Even if they have a car, they would be able to access this. You're welcome.
Thank you so much. And thank you for your comment about, what you said about the hug, that you support the hug, the union supports the hug coming in and going out, because I know I've spoken to parents where they're even like, if I could just have a hug. And so I really appreciated hearing that. Commissioners, do you have any final comments or questions before we say thank you to our panelists? Okay, and with that, panelists, thank you so much, and we'll move to a short 10-minute break. Can I have a motion to recess for 10 minutes?
A recess for 10 minutes.
Thank you. Commissioner Kakani, seconded by Commissioner Shipp. All right. All right, so it's 11:25. We will come back at 11:35. Thank you so much. Enjoy your short break. Thank you so much to our panelists. Thank you. That in the item, we're on agenda item 5. Okay. Do we have everybody back already? Our panelists? And our panelists are here too? Okay. Okay, great. Thank you so much. So for agenda item 5, we will discuss and take possible action on issues related to probation's proposed budget for next year, the use of contracted consultants, and the department's work to ensure that money intended for supportive services for preventative and SYTF youth, known as JJRBG and JJCPA funds, is spent on programs serving those youth. Joining us to give verbal reports are Probation's Administrative Deputy Stacy Lopez Maddox, POC Director, Project Director Donisha Smith, and Commissioner Brooke Harris, who will report on the POC's Budget Ad Hoc Committee's progress. Commissioner Harris, can you start us off, please?
Commissioner Harris and I are trying to do sign language. Do you want me to report on what we've received? Did I do a good job reading your mind over there? Okay. I will report that there was a request that was made at the February 18th. I might totally be making up that date. POC meeting via a motion that was a request for additional information about 10 of the contractors. And that information has been received by the POC. It's a lot of information, and staff and the committee are going through it and making sure that everything is there that we asked for, and also creating some useful summaries for discussion for the committee that makes it difficult to, maybe I should say, inappropriate to discuss it today because we haven't looked through it all. So that's where we are with having received that. So no need to take any additional action on the outstanding information.
Thank you. So we're going to move on, and I'm going to sort of direct some of my comments on the larger conversation about the budget, which Ms. Lopez Maddox is here to discuss with us, and the chief is here for the time being as well. When I think about probation oversight, I think the budget is a really important element of oversight. It's incredibly important for the public to understand what the department's budget is, how they're allocating the funds, what they're being used for, and what the results are, right? What the impact is. On the budget subcommittee, we've begun to ask some questions. I think this contractor question is one of them. And, for some of the things that we've been discussing, we've found more questions than answers about, things like how the emergency order impacts the budget and, additional funds that are available, the vacancies that are, an issue, and then how monies are actually used. In this year's budget, as in some of the documentation that we've gotten, there's two sort of gigantic budget items, the two biggest budget items, 40% for juvenile and young adult custody and rehabilitation, and then 36% of the budget for field services and adult investigation and supervision, juvenile and adult investigation and supervision. I'm sure, we'll have questions about that, and looking forward to hearing, sort of digging into those a little bit more. But, we appreciate the transparency around the budget, and, the questions like how many staff are actually coming to work and what are the services the young people are receiving. That's all connected to the budget. So, we'll look forward to hearing from you. I know you can't answer everything, but this is a really important topic. So I'm going to turn it over to you, Ms. Lopez Maddox.
Okay, I'm on. Thank you, Commissioner Harris. And we feel the same way about the budget. It's a big responsibility for us here in probation to have such a significant budget where we have different sources of revenue and also different departments that we also help out and contribute because of what we do. I wanted to just give a high-level overview of our budget that we proposed on February 17th, and for the folks who weren't able to watch it, and I think we're going to put it on. I think it's on screen, Wendy. So probably for the viewers. So our key priorities for the year and continuing with what we've been doing is, implementing the depopulation plan, as you heard earlier, complying with all of the BSCC staffing requirements, because as you know, that's been a challenge for us. Our WIC requirements to maintain a juvenile hall, and then complying with Department of Justice settlement, as everyone's aware of, that we've been working towards. Recruitment and retention, as we've talked, so there's been some discussion about today as well, and in prior meetings, and also at the board meetings as well, with how we're recruiting and how we're keeping our folks employed. So those are our key priorities as we continue into next year. We talk about how we are enhancing public safety, our active supervision, and again, this is as of February, so I apologize, some of the numbers have obviously changed since then, but this was the February report that we gave out. For active supervision, 24,788 adult and juvenile caseloads, rehabilitation of the most high-risk youth, 269 youth in the juvenile hall, 171 youth in a residential camp program, and 143 youth in a secure youth treatment facility. We provide a number of rehabilitative services, as the public is aware, and we'll continue with those and be funded for those. Our budget requests, we have a $1 billion budget for the Department of Probation, and for 26-27, our new appropriation request was $36.4 million. We have some unavoidable costs that we're working on reducing, which is our workers' compensation and long-term disability. The department is working on figuring out solutions and getting people back to work and figuring out how we can reduce these costs. As the public has heard, and the POC has heard, that we're working on pretty much regularly to get folks back. We did request a position for our internal affairs unit. That is something that's been critical to our department as well, and continuing to ramp up the staffing there to further support our department. And also AB 1869, Families Over Fees Act, state backfill funding was part of our ask, $7.8 million. Services and supplies costs. The costs that are associated with this, we have a number of contracts that we procure with other departments in the county who support our department as well, and our juvenile and adult services. And so with anything, costs increase. And so we've seen an increase in our county services costs. So that was something else that we had requested within our 26-27 budget. And again, it's just a high-level overview of what we asked for. And a lot of things we are self-funding. A lot of the changes that we're making within the department, we're using internal funding. So I think that if you look at the budget overall, we're really trying to be mindful of how we're spending this, and also looking at things of how we can reduce costs as well, moving forward into the next year, understanding the county, the state that we're living in today, and ensuring also that we're getting the proper services for the right amounts of funding that we have. So any questions on that piece?
So I guess I think the very last sentence that you said is the crux of it, right? Proper services for the right amount of funding that you have. And, I guess what I'd love to hear from you or from the chief, and this is rough math, so bear with me, but, roughly you're spending $400 million on the juvenile and young adult custody and rehabilitation. Is that that's my calculation, right? If that's 40% of your budget's $1 billion, roughly 400 million on that. Sort of roughly the same for juvenile adult supervision. So I guess, I have this question of, broad strokes, can you tell us what $400 million is being spent on for the 500 youth, roughly, I'm doing broad strokes here, 500 youth you have in custody, given all the issues that we know about, the staffing, the, safety for youth and staff, and all of the things that we talk about at every POC meeting, BSCC compliance or non-compliance, all of that stuff. What is that money being spent on? And then broad strokes, we've heard a lot in recent meetings about decimation of the field for adult and juvenile field services. So again, what is that money being spent on? And where's the correlation, between the proper services for the right amount of budget that we're discussing here today?
Do you want to take that one?
Yes, Commissioner, I think you've jumped to really the analysis and the right question, which is when you take a look at the amount of money being spent to run a juvenile hall, does that make sense? And if the approach were to treat probation like a for-profit or a business, then the answer would be simply, no, that doesn't make any sense, right? Because you would reduce it to a per youth cost, and that wouldn't make any sense. We have a unique task as a governmental entity in which the resources that it takes to maintain the required juvenile hall and the safety sort of is secondary. And what I would say is that many of the costs are actually outside the control of probation, meaning as we decide in the coming year where we would like to spend money and the services we'd like to spend money in, frankly, that would be aspirational because most or heavy chunks of the budget would actually be controlled by external factors, such as if we have 35 or 40% of the staff that need accommodations and are unable to do full duty, then we don't have the possibility of simply saying, well, we're not going to pay overtime to cover behind them. And that's a cost that's not accounted for or anticipated, but really there's no alternative because the minimum requirements beyond the BSCC that are required as part of the litigation that we have with DOJ, the county has to bear that cost. There's a whole host of other services that go through the probation budget, but that really aren't about probation providing services, such as other county departments that provide services in the juvenile facilities. So in that case, you'd have to tease out what percentage of our budget is really a pass-through to services that come from other county departments. And I think you'll find that that's substantial. And so really, I think the question is when we peel back and say, of the funds that are available to decide what type of programming or what type of model we'd like to, how much of that is available? And you haven't seen a whole lot of that. What you've seen is a whole lot of reactionary, sort of emergency type of behavior in how we've been spending. So the criticism, I suppose, would be, look, what is the long-term plan? What are the things that we can do to curtail some of these portions of our budget that really are excessive for the amount of folks that we are providing services to? And we are doing those. And so it is, in fact, in many unpopular policy decisions that are going to be criticized because they're difficult. It is things like saying, well, we can't just be working officers on overtime routinely to fill the necessary spots. That really what needs to happen is you move officers from the field to work in the facilities, regular shifts. That not only is required in order to make sure that we're following the state standards, it's required in the agreement that we have with DOJ. It's also the right thing to do from an employee wellness and from a budget standpoint. That actually has an impact, for example, on how much money we're spending in order to run facilities for 500 to 600 young people. Then there are small things that you have to take into account, which is we usually talk about average daily population. That's not really the total amount that we're servicing, right? So if we say an adult, the ADP may be 20,000, but in a 1 year, we're touching many people in the hundreds of thousands. So when we do the math, we have to account for the total number as well, not just the ones, and then the math starts to shift and look a little different. And then what we seek to do is be transparent that there have been investments in things that we think improve quality of life for the young people and the employees, but they're a hit to our budget in the short term because we've not sought additional money to do it. Typically, when you seek to professionalize a classification and say, look, what we're asking probation officers to do today is different than we did before, and we need to make sure that they're better trained, that they're a higher classification, that we're more market appropriate in terms of compensation. And we undergo a process of saying, we don't think the GSN classification is appropriate. I really want to hire DPO ones for this classification, and that's who we're going to go after. That costs more money. We think that there'll be dividends here to show in the years to come as we have better prepared folks and we're recognizing and we'll be able to fill more spots in terms of recruitment. But you'll see that in the budget because you see this sort of contraction in terms of taking all these positions, reducing them so that we can have employee. That's just one example. When we talk about creating better environments in home life, that's extraordinarily expensive. So every small thing, which is increase visitation, increase in the facilities where young people can have better interactions with their attorneys and healthcare professionals, that's a huge chunk of money that we don't control the costs on. We approve what we think should be done, but then sort of the amount of money that cost is external. So I know I'm not providing a complete picture, but what I will say is, in terms of our belief system, we know that's for the juvenile communities that we are in a transition phase of creating environments that are based on smaller communities. And I know I keep saying it, but in which the probation officer is just one of many departments and externals that are providing services. That is not reflected directly into the budget, but if you dig deeper, you see that some of the costs being borne are in order to move in that direction. There are a whole host of other costs, like I mentioned before, that are not controlled by us that have to do with the litigation that we have. And as anybody has a settlement knows, those are tremendous and they can double the costs of operations, but really aren't up to the department. They're not voluntary. They certainly aren't something that I have control or can discontinue. And then, but it comes at a cost. And I think you've heard, whether would you agree, I agree in entirety when the union or field deputy probation officers come before you and tell you that it means that we're not doing something in the field. That also is true. We have reduced the number of our offices in the field, so we've contracted our space. But the things that we're trying to do is look at other classifications that are not peace officers that can still provide resources to, and we're doing that through the parole assistant classification. And in terms of our strategy moving forward, we acknowledge that doing business as usual and simply saying the answer to everything, the answer to community supervision is having a probation officer with a small caseload. That's unlikely. So what are other strategies that we can utilize in terms of determining who needs the most services, when do they need them, and what types of employees can I use to make that? And we're doing a lot of that through contracts. It's simply saying if there are community networks that can provide a lot of this, then we just want to make sure that the probation officer is the liaison versus the service provider. I'll stop there, but that's sort of the overarching goal on how we're approaching providing services to adults and juveniles. I'll leave to Stacy and the rest of you are very much more specific in terms of the budget. But I would just point out again, if you remember something, it's that we're a pass-through for much of what you see in terms of that $1 billion. And we're passed through not just on the contracts for nonprofits or providers, but also to other departments that provide services for us.
Thank you, commissioners. Yes, Commissioner Kakani.
Do you have an amount for that pass through? Or is that is that a number that you can provide?
I was just going to add to what the chief mentioned. We can break it down for you to show you all the funding that goes to other sources, other
Okay.
departments, we
Yeah,
have
that would be super
I think that
helpful.
would paint a clearer picture on when you see it's really not the 400 million that we have. So we'll get that for you.
And then your so what is your juvenile institution's budget request for this year? Is it 400 million, or I'm just because historically it's been closer to 500 million, so
It's
or 423, 430, sorry. So just curious what the juvenile institution's budget is, or what you're requesting.
we were not requesting, so that's not part of our 26-27 ask. So it's ongoing internal funding that we're using, but not to say that we won't be asking the next fiscal year
Yep.
because of everything that's, we need to be in compliance with regarding DOJ. So that will be for the following year, I'm sure.
So do you have a number for 26, 27? Like what your
of what
juvenile
we're
institution's
spending?
budget?
I can get that for you.
Okay. And then sorry, lost it. There was a number of itemized positions. I can't remember, items, sorry, whatever they're called. Can you share how many of those are vacant? I think it was 4,000. Sorry, I'm just going to find it real quick. Right, okay, so budgeted positions currently were 5,001, and now recommended budget, or what you're requesting, is 4,958. Thank you, Commissioner Meredith. Can you share how many of those are vacant?
I don't know right at the moment, so we can get that.
Okay, you can provide that.
Can I jump in on? I have some information from the August 27th, 2025 CEO budget analyst report. It was from Public Safety Cluster, I believe, on 9/17/2025, that the department had 1,268 vacancies. Does that sound like it's still
That sounds close,
pretty accurate?
Chief.
That sounds right. I think it's probably closer to 900 on the line level staff, and then the remainder of those, a variety of other classifications.
Okay.
If you could provide that breakdown, it would be super helpful. And then, sorry, trying to also take notes before I forget. You said something, Chief, about settlement costs, and I think that meant not necessarily for the attorneys or litigation, but as it relates to implementing terms of the stipulated judgment. Do you have a breakdown of those dollars? How much is the department spending to come into compliance? And I think Commissioner Shipp has asked about this too. So if it's, the depopulation plan, for example, isn't an attempt to come into compliance with title regs for the Board of State and Community Corrections, or again, this massive stipulated judgment with hundreds of terms. Is there is there a document? Is there a way to tell us how much you all are having to spend to come into compliance with these things?
Yeah, I don't have that today. I appreciate the question. Let me go back and prepare something that is, I think that'd be helpful for all of us.
Yeah.
Folks to understand. I did mean the stipulated judgment. I don't consider, for example, the BSCC regulations that's different. But I also do mean attorney costs. I think that's an important component of what the department is spending in terms of our DOJ settlement.
And just to add to that, even just our facility improvements that we have listed that we need to get into compliance, that's going to be a huge dollar amount. And those are things we're already working on and have been, so that's a big piece of it too.
Okay, and then last question. I think I saw your memo about you know, kind of moving away from these temporary reassignments and permanently assigning people to the halls. I guess my hope is that will ultimately reduce the amount of dollars you all are spending in overtime. I just, how does that impact the budget, right? I mean, I know that oftentimes dollars associated with vacant positions are kind of being used to stop the bleeding. But with this new plan that is, again, not designed to just stop the bleeding, but be more of a permanent shift, like what will be, my thought is that it would be, I guess, less of an impact on the budget, right? Like if you're moving folks who are in the field, permanently reassigning them, perhaps, you know, hiring more probation, or I think you might have said parole assistants, like what is the impact on that budget? Is it still a billion-dollar budget, or does that shrink the budget a little bit? Does it, I don't know if there's been any sort of like budgetary analysis or like, I don't know, like ROI, cost benefit, anything that's being done.
Yeah, no, that is the hope. So the hope is that in addition to all of the other things I mentioned, that would push down on the amount of overtime, especially mandatory overtime that's taking place. I hate giving predictions. I've missed in the last 7 I've made because much of it has to do with the behavior of others. And so it depends. It depends on how many officers actually show up. It depends on the continued behavior that the call outs are better, but it depends. But the idea would be that we would be spending millions of dollars less on overtime, mandatory overtime, but there may be, and by the way, it's not that then we have a surplus because we're covering through vacant positions a whole host of things that are not accounted for in the budget. One of them being the additional overtime that we're not budgeted for, but there are other things such as the workers' comp and all of that other component. It doesn't fix that. But I'm in line with you that I would expect to Q1, Q2 after implementation to start seeing a push down on that overtime. The probation assistance is a long-term project to make sure that we are saving the work of peace officers for where they're mandated, but that we can still provide services, case management and such to all of the adults that we have on supervision through that non-sworn classification. So that's a long-term strategy, whether folks were to be sent into the facility or not.
Sorry, with that, I don't know if it's helpful to make a motion, just like naming these things. Okay. Again, I don't take great notes, and so let's hope we can cover what I just said. I would like to make a motion to request data on the number of vacant positions and a breakdown of those positions. I would also like to request a breakdown of the dollars that serve as like a pass-through for other county departments or community-based organizations. I would also like to request a breakdown of the cost to come into compliance with the DOJ settlement. So whether it's home-like improvements or revised staffing plans, whatever it is. And maybe also in connection to that, the cost that has been associated with the implementation of the depopulation plan. And is it? And and then I mean, I think I heard you say that, you know, often you're using the dollars associated with vacant positions to kind of cover a whole host of things. And so also what those vacant position dollars are being used to cover. Okay, I think that's it.
The costs that are non-fund. So there is a report that I think is a public report, and one of you may know this better than I do, that is I'm forgetting the term for it, but it shows when a department, not just probation, any department is moving funds from one bucket to another bucket during the budget year, not as a part of the budget cycle. Am I making that up?
No, you're not. We also have public reports on our vacancies that are required now through a separate
Right.
state law, and we routinely report on, I think half of these items are already in public reports, but we could certainly
Right.
gather them.
Okay. Commissioner Kakani, if you would allow for some flexibility for me to find out what that report already is, that I'm only talking about the last thing that you said, how the money that it would have been spent on vacant positions is spent on other items. I do think I can get a report that says that, and I can work with Stacy to make that happen. So can I read the list of the things you said? Number of vacant positions and the breakdown, the dollars that are passed through to other county agencies and outside organizations, the dollars for compliance with the DOJ settlement, and the dollars for implementation of the depopulation plan, some of which are
Of the cost of depopulation plan is a separate thing. We'd have to sort of enter in conversations on what you mean by that, because many things both solve the DOJ requirements and depopulation, and so it's not singular. All of the other items we report on publicly routinely. So if the commission would be open to us producing those or giving you those reports, yeah.
often when you've done these motions, not you, the commission, you've said something like authorize the executive director or the staff of the POC to work with probation to fulfill the request if
I
you
will add
wanted
that.
to. Okay.
All right, do we have a second on Commissioner Kakani's motion? Seconded by Commissioner Shipp. And then now take a vote. Oh, yes. Is there any other questions or comments before we move on to public comment? Yes, Commissioner Shipp.
Maybe you talked about this a little bit, but on this new budget request of around 43 million, 33 goes to services and supplies. Can you expand on that a little more, or would you need some time to expand on that?
Yes, no problem. I mentioned earlier, that's regarding the services that we contract for with other departments in the county. And so county costs have increased. And so the costs then increase for probation since we contract with a number of these other departments. And that was the breakdown too. We can provide that with how much we're paying other departments.
Okay, thank you. Any more questions?
Yes. Yes, also we'll take public comment first and then come back to you before voting. So the motion says, provide information on the number of vacant positions and a breakdown of those positions, on the dollars that are passed through probation's budget to other county agencies and outside organizations, dollars for compliance with the DOJ settlement and the implementation of the depopulation plan, and authorizing the POC staff to work with the department to fulfill the spirit of the motion. Okay, so we'll move on to public comment. Is there anyone in the room who would like to make public comment, or anyone online? Please use the raise your hand function. I don't see anybody in the room. Thank you. We'll go to online commenters and start with call-in user number 6.
Yes, good morning. This is Mel again. I have just 2 questions. As we're talking about the budget for the upcoming proposed budget for the 26-27 year, 2 things. One, I noticed that it was said that there wasn't really an item for workers' compensation for the 25-26 fiscal year, seeing as how it seems to be an unfortunate reality would it be reasonable to conclude that that would be those, or that there would be some type of item line allocated for workers' compensation for the upcoming 26, 27 fiscal year budget? And again, you know, it's an unregrettable situation, but it appears to be a reality. And then secondarily, currently we have the probation assistant position that is defaulted for those deputies, for those officers and deputies that are physically unable to fit the needs of the department at this point. As it relates to supervisors, directors, senior directors who may fall in the same or similar circumstance, will there be any equivalency allotted for those positions as it relates to, I mean, I don't know what the title has an equivalence or something that is symmetric to the probation assistant positions that has been slated for the current DPO 2, 1s, BSOs, and so on and so forth. Thank you.
I think the department would like to respond to a couple of those, but let's go to the next public commenter and then we can wrap it up in case. So the final commenter will be Crystal Jones.
Hi, everybody. I'd like to offer a practical recommendation around maximizing existing resources, specifically how we can better utilize those unspent or underutilized funds. In many cases, funds are allocated with strong intent, but due to timing, capacity, or procurement limitations, those dollars are not fully deployed within the cycle or by the deadline. Rather than allowing those resources to lapse or go unused, there's a real opportunity to redirect those funds in a way that creates immediate impact. One solution is establish a structured pathway for transferring or reallocating unspent funds to vetted community-based providers as subcontractors or direct service partners. Organizations like the one I represent, Crystal Clear Learning Foundation Incorporated, are already positioned with program models, staffing frameworks, and strong community relationships in place. And what is often needed is timely access to funding to activate those services quickly and effectively. By allowing flexibility in contracting, whether through emergency allocations, pilot agreements, or expedited subcontracting, we can move from delayed implementation to real-time service delivery. This approach does three important things. First, it ensures that public funds are fully utilized for their intended purpose, serving youth and families. Second, it expands capacity by bringing in trusted community providers who can operate with cultural responsiveness, um, and and accountability. And third, it allows us to scale resources more efficiently, extending services like housing, mentorship, workforce development, and behavioral support without starting from scratch. This is not about creating new funding streams. It's about maximizing impact from what we already have existed. Thank you.
Crystal, you didn't say it explicitly, but there was an item also listed on the agenda regarding unspent funds. So I don't know whether the commissioners want to ask the department to also respond to that question, or if you wanted to add anything to that question.
If it's not too late, would love to add that piece around JJRBG and JJCC unspent dollars.
Usually better at this. With respect to the probation assistant, because these are civil service positions, I do need to make clear that it's a classification that was created after doing an analysis of functions and duties that would better align with a new classification and would expand the pool of folks that would be available to be hired and qualified for the position. And so it was an assessment of the entire department if we're utilizing our resources as best we can. It was not intended for peace officers that can no longer perform those duties. It happens to be that some of the best qualified folks to do that work, because there's overlap, are folks that were full performance in the behavioral sciences, which happen to be DPOs. Who better positioned to do it? It is also true that when a department has positions that are vacant or items that are vacant, and you have someone going through the process of leaving the classification they're in, that you see where you have vacancies and what they qualify for. So it's fortuitous from my perspective if our probation assistant positions are filled by folks that are already experts in the area, but I just need to make clear that we still use all of the same process to determine who's eligible and who should go into that position. It's not a classification exclusively created to offset folks that are no longer able to perform peace officer functions. And that in fact, the classification could have an exam open tomorrow for people from the public to put into it. So it's just the reality of where we are today and the number of deputy probation officers who need an accommodation or have permanent disabilities. And then we have the creation of this position, but that's not the reason it was created. And to that extent, then it would answer the second question, which is if we're going to create more positions that are at a higher level. That was already something that we looked into, and it was determined at this time the classification as a single level is what would be appropriate, as they can be supervised by SDPOs or non-sworn staff, depending on what they're doing. With respect to the other, there is this race sort of at the end of the year to make sure that funds are spent because we know there's a need. We do have some limitations, and I'll let Stacy talk about other nuances here, but most of the contracts that we have really are paid via invoice services. It's not an amount of money that goes for services that will then be done. And so that makes it difficult because it means that the service provider or the entity has to have their internal capacity to be able to bring on resources, and knowing that the funds are going to come later because you're billing to services already provided. It's not exclusively that way, but that's the majority of the contracts that we have. And so it makes it difficult because there's a lag after there's an award for the service providers to be able to bring on providers to do it. Then they actually have to provide the services, and then they have to bill. And that's in part why you see at the end of the year that we may have projected or maybe even encumbered that we were going to have certain costs, but it doesn't play out that way. And then the service providers are in a tricky position because they're saying, look, I need the money to be able to go do those things. And we really don't have a way to do that.
And just to add to what the chief was talking about with unspent funds, I know there were some questions about the JJRBG and the JJCPA grant funding that we receive. And there are unspent funds in both of those. And probation is truly the administrator. That's our role for this. We get the funding in our budget, but we are the administrator. We don't have all this funding in our necessarily, we don't get all the funding. There's a committee that is established, that was established years ago, that makes decisions on where this grant funding goes. Typically, it's for the community-based organizations, and there is a significant amount of money that comes in from the state every year for both of these grants. And so I think there's a little misconception that we have the money and we spend the money, but it's not probation's money to spend. We have a very small portion that we use for community-based organizations, but the ultimate decision for both of these grants is based off a committee who makes the decisions who should get the funding. And there's the funding given, at the committee hearings, and sometimes money wasn't spent from the previous year. And so people are seeing that and seeing the last 4 or 5 years where that's happened and significant amounts getting carried over. And I had the same questions when I came into this job and like, how does this work? How do we get to keep this money? But there's so much money coming in. We need to look at ways of how we can better find community-based organizations that can spend this money, because it's a substantial amount that we get through these grants. But again, we're the administrator for this, and a number of departments do have money or do get funding from both of these grants. But it is definitely something we need to figure out a plan moving forward, so we're not carrying over so much unspent funds.
Is there any more questions or comments before we move on to vote on the motion? Okay, with that, we take an aye vote.
Okay, so we are voting on a motion by Commissioner Kokani, seconded by Commissioner Ship, to request data including the number of vacant positions and breakdown, the dollars passed through to other county agencies and outside organizations, dollars for compliance with the DOJ settlement and implementation of the depopulation plan, and to authorize POC staff to work with the department to ensure that is fulfilled in the way that it was intended. Please vote yes, no, or abstain. Commissioner Harris?
Yes.
Commissioner Kokani? Commissioner Meredith? Commissioner Mundo has stepped out. I'm sorry, I failed to mention that earlier. He had another meeting. Commissioner Ship? Yes. Commissioner Terry?
Yes.
And Chair Canales? Okay, so 6-0, the motion passes.
Okay, and with that, we are concluding this agenda item. Thank you so much to our panelists for joining us today. And we will be moving on to agenda item number 6. All right, thank you very much.
Okay, this is, I will be very quick here, but I'm glad to have a few minutes to recognize the awesome work of my staff. The commission has launched its 2026 inspection cycle led by Dr. Sarah Gongora, and we've actually already completed one of the inspections at Campus Kilpatrick and have sent some initial findings to the department and are working on the full report, which will come back to the commission. And then be shared with the public and the board and the BSCC. We will conduct the rest of those inspections throughout the year, and I really appreciate all the effort of the staff and the commissioners who spend often many, many hours at the facility and then also write up their notes. But I'll just say I had a great day last week with the young people at Campus Kilpatrick, and they really make it awesome to be able to talk to them. They're so thoughtful about the things that they have to say. And we've, I think, done a better job of capturing some of the actual direct comments from young people who are detained, as well as the staff who are caring for them, not just probation staff, but also partner agency staff. And I'm really pleased about how those inspection reports are feeling very genuine in terms of the reflection that the BSCC asked us to do when we first learned about our role in this, which is to provide a perspective about how it would feel if a member of my family was detained in the facility. I also want to say thank you to our communications team. There is a first quarter key performance indicators report linked here, which shows the exceptional outreach work that's been done. And Ismael and Belinda spend a lot of time editing those really awesome videos that you see on YouTube and social media. And also thank you to the stars of our videos, our commissioners and the public commenters who we love to profile because of the really smart things that you say. And then also under this agenda item, we have a list of detailed reports that have been received. And the data and research team led by Donisha and Analicia and Tyler have really been very helpful to me and to the commissioners in helping keep close track of what we're supposed to be receiving, and then probably most importantly, actually analyzing it and reviewing it and sharing it in a way that's consumable for the commissioners and the public. So there's lots of information there, including some reports on OC spray, some reports on intake trends, and other things that I think do a beautiful job of illustrating both some of the issues that we've discussed and also some of the continuing challenges that the department is facing. So with that, I will say thank you. And I don't need any action on any of the items in this report today. And I guess we'll take public comment unless commissioners have any questions.
Do you have any questions?
Okay, any public comments on my riveting report? Thank you. I didn't actually mean to pressure you into giving public comment, but thank you for obliging.
Hello, hi everybody. My name's Librado Clemena. I'm from the Central Cha.
nonprofit organization downtown Long Beach. And man, I sat in here and I listened to the whole thing. It's amazing how the commission, the job that you guys are doing, how you guys opened up. But one of the things that was standing out to me is that I'm system impacted myself. You know what I mean? And I've been through all the youth programs and all that, you know, the LP, Central Juvenile Hall. I've been through it all, through the California Youth Authority, everything. And when I hear what I heard, the comments being made, right? I kind of sat there. I kind of felt uneasy for a moment, you know. But now that I'm older and I see things differently, I understand. However, this what 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 needs to be done, or what my thing, my view on everything that was said today, is that the kids need some type of guidance. It comes from the home. You know, it starts at the home, and then not only that, and you carry it on out into the schools, and then it goes into, you know, they start hanging around with the wrong crowds or what have you. I put right here, you know, they need more productive youth programs, mentor programs, community service. Somebody was saying, you know, family reunification in the juvenile halls. Get the parents involved. When I was in juvenile hall, my parents they weren't involved in anything. You know, have some type of family therapy, group therapy inside those juvenile halls, in the camps, Camp Gonzales Rocky. I don't even know if there still exists, but I've been through all of that, you know, and what I missed back then is I know that the kids miss today too. You know, is reuniting with their family. There was no love out in some of our homes. There's no love there. You know, that's why we go out to the streets and we do what we do. There's nothing there for us. There's no mentorship, nothing. And that's what these kids are crying out. In the organization I work for, you know, we have several programs there, right? And what do you call it? It's like I hear it every day. They hear it, my coworkers right here, they hear it every day, because we have the youth.
I'm going to get accused of bias if I don't cut off my Long Beach Central job.
Okay.
And it might be true. So.
No, but I just wanted to put
Thank you.
that out
Thanks
there,
for
okay?
being here all the way from Long Beach. I appreciate it. Some of us
Thank
make
you.
that drive to all of the meetings, and I really appreciate it. Do we have any online public commenters? No. Okay, so we can move on. Thank you.
Okay, thank you. And there will be another opportunity on agenda item number 8. Okay, don't come up on 7, it's 8. So with that, let me see. And I just want to also comment on what you said. Thank you for sharing your truth, but addressing the whole picture, because sometimes I think we just want to look at it from one side, which makes it very problematic to come to a solution when we're not talking about the realities of some of what the youth endure also at home. And so thank you for that. Now, let me see. So we don't have any calling comment. Commissioners, do you have, yes, Commissioner Meredith.
Okay, so before, I think he's to item 7. Did you already do that?
Oh, okay. Okay, so is this on number 7, Commissioner Meredith?
Comments?
Okay. So this is still, so now we'll move on. Since there's no more additional comments or questions on agenda item number 6, we will move on to agenda item number 7, matters not posted on the agenda. And this is for commissioners and POC staff only right now. Commissioner Meredith.
Yes, I want to recognize that April's an unfortunate month for us. On April 5th, 1994, Arnold C. Garcia was slain at Dorothy Kirby, and his memorial was on, like I say, April 5th. April 30th, 2021, Michael Wall died at Eastlake Juvenile Hall, Central Juvenile Hall in Eastlake, performing his duties. So I just want to make sure we remember them.
Thank you for uplifting that. Commissioners, any more comments or questions? Okay. All right. So now moving on to agenda item number 8. This is an opportunity for the public to address the Probation Oversight Commission.
Anybody want to make comments on things not on the agenda today? Use the little raise your hand function online or dial *3. Go ahead, Thomas.
Hello again. Before I leave, I promised them I would do this. There's an organization that comes to Camp Alpha Ball. I believe they're at Rocky. They're a sports program. This is an excellent program. These guys work with the kids. They have them out there playing sports. Right now it's football, and they do a wonderful job. So I wanted to lift them up. And also they have a championship game. It's Rocky versus Alpha Ball. They're going to play it at Page. And if you guys would like to come, I know you guys got access all the time. Please be welcome to come. I told them I'll invite you guys. When? It's April 18th.
Saturday.
Yeah, Saturday, April 18th. Call, make sure it's still going on, verify everything.
I've got the info. I'll get it to you.
There you go. I told them that I would invite you guys today, so.
Can you say the name of the program?
It's called Affirmative Athletics.
Yes, thank you, Ms. Wendy. Mr. Rob is in charge of it. Excellent program. And you guys want to come out, see the kids play football? I watch them practice all the time. I love it. Thank you.
I believe it's actually indicated in our inspection report from last year that one of the problems with that program is that there were some other programs happening at the same time as that program, and all of the youth were crammed into one classroom to be part of that program. So yes, it's very popular.
Hi, my name is Star Williams. I am a clinical law student with Loyola Law School's Juvenile Justice Clinic and Youth Justice Education Clinic. It was a pleasure being here today and hearing everything that was discussed. But I am here to advocate for the depopulation of our juvenile facilities. I acknowledge the concerns that were discussed today in regard to public safety. However, true public safety is not achieved through incarceration alone. We must recognize that youth in these institutions, regardless of the charges they face, are often victims themselves, having survived years of systematic neglect or trauma and lack of resources. Currently, our oversight model is failing their most basic right, and I would say that is education. Education is not a luxury or a privilege to be used as a bargaining chip. It must be the backbone of rehabilitation, in our opinion. And I urge this commission to ensure that probation does not interfere with educational access. We must shift the lead role for programming away from law enforcement and into the hands of youth development and education experts by prioritizing community-based alternatives and ensuring every child has access to college pathways and vocational training. We stop the cycle of harm caused by restrictive environments. True oversight means treating these kids like the vulnerable youth they are and providing a seamless transition back into their communities. Again, while public safety is very important, it's also important that we consider the youth and their backgrounds and their situations as they have also been affected by these systems and failed by the systems as well. Thank you.
Thanks, Ms. Williams.
I'm back. No, Libralo again from Central Cha. What I wanted to finish, my colleagues were telling me, go finish. The programs that we provide at Central Cha, we have the workforce reentry. I'm a case manager for the workforce reentry. I help the formerly incarcerated adults from mine is from 24 on up, I believe. They work with the youths from 18 to 30, and then we have a safe passages team. We have the community violence intervention. We have the promotoras for the immigration, and what the stuff that what I utilize with my program is evidence-based curriculum, right? And we provide housing, not housing, rental assistance on a case-by-case basis. We send them out to get the training of their choosing, as long as that we can, find the appropriate trade school or schooling or college or whatever. We essential clothing, we give them bus passes and stuff like that. But the thing is that our doors are open to everybody. It might mean Central Chaw's Community Hispanic Association, but we service our services to anybody that walks through our doors. You know, I mean, providing that they meet the criteria as far as, you know, being an ex-felon or having a criminal record or what have you. Other than that, I'm looking at this clock and I'm getting nervous. I appreciate you guys, and I hope that this we can see some great changes within the juvenile system. Thank you.
Thank you. And we'll go now to our online comments, and we'll start with Crystal Jones.
Hi, everybody. I wanted to take a moment to intentionally uplift the importance of centering people of color and community-based leadership and how we design and implement solutions. The youth most impacted by probation systems, housing instability, and reentry challenges are disproportionately, excuse me, disproportionately, I'm trying to get it out correct. Sorry, guys, while the parents coming in. Youth of color. So majority of them are youth of color. And yet too often the organizations closest to these communities are the last to receive access to funding, contracts, or decision-making power. If we are serious about equity, then equity has to show up in action, not just in language. That means creating real pathways for community-rooted organizations like Central Chai, Long Beach, and Crystal Clear Learning Foundation Incorporated to be engaged as direct service providers, subcontractors, and implementation partners, not after the fact, but at the beginning of the process. So now we are not starting from zero. There are already culturally responsive, trusted providers who understand the lived experience, just as he shared, of these youth, who reflect the communities they serve and who can implement solutions immediately. This is where urgency matters. We don't need to wait to design new systems. We can activate what already exists and what's available by prioritizing partnerships with providers of color and brown Hispanic providers that already have the experience and actually have the entities to streamline access to resources. We can expand services quickly and increase trust and improve outcomes. This is how we move from intention to impact by investing in those who are already doing the work. We create not only solutions, but sustainability, leadership, and long-term change within the very communities we are trying to support. Thank you.
Thank you, Crystal, and for putting so much effort into your comments today. Thanks for being here. We're going to wrap it up with Mel Bailey.
Yes, thank you. My comment today is to the POC in its entirety. Your help is significantly needed. I say this because some of you know some of the volunteer work that I do. And I had one of my mentees reach out to me because he saw the advertisement for becoming a probation employee. And in his research, he stumbled across the POC and watched some videos. I just want to ask, it's really important. I do want to recognize that a good amount of you have been very supportive, and I really appreciate that. But it's going to take more because unfortunately, just like in our situation, the bad seems to outweigh the good when it comes to public perception. And when you have individuals who stumble across the POC videos and you have a commissioner who is speaking down to our chief, our leader, and I understand you get frustrated and we get frustrated, but it's not okay for us to do that. It's really important that the commission supports the probation employees from the clerk all the way up to Chief Villarosa are filled with just an overwhelming amount of impactful individuals that have dedicated their lives to this community. And it's really important that the POC, you have probation in your name. It's really important that you all are supportive. You don't have to agree with what's happening, but especially when you have people watching these videos that stream internationally, it's important. Otherwise, we're never going to get this employment rate back up. It'll never happen. But you are a very integral and critical part of this.
Concludes public comment. And so now we move on to agenda item number 9, adjournment of the regular meeting of March 12th, 2026. Thank you all for joining us and for sharing your comments. As a quick reminder, be sure to follow us on social media and subscribe to our YouTube channel at LA County POC. And to receive reminders about our upcoming meetings, visit our website at poc.lacounty.gov to subscribe to our email listing. It is now 12:41 p.m. Can I have a motion to adjourn today's meeting? Motion to adjourn by Commissioner Meredith and seconded by Commissioner Shipp. And so now could I please have an aye vote? Right, with that, motion is adjourned. Thank you so much.